Terrific. Good morning, everyone. My name is Felicia Ward, hearing officer appointed by the Secretary of the Environment Department to conduct a hearing in the Environment Department versus the U.S. Department of Energy and Solido isolation mining contractors. The number on the administrative order as issued by the Compliance and Enforcement Division was apparently 2504, but I'm always going to be referring to the matter as HWB 25-51. That's how the hearing clerk, Luis Lopez, docketed it. So that's how we refer to these matters when we have a request for hearing. The hearing will be conducted under the department's adjudicatory procedures applicable to compliance order hearings. That's 20.1.5 of the New Mexico Administrative Code. All testimony is taken under oath and subject to cross-examination. No decisions will be made today or this month after we have a transcript prepared by Mr. Aragon. We will have post-hearing submittals from the parties, a hearing officer report, and then, as I understand it, there's been a delegation for the final decision in this matter to Deputy Secretary John Roderick. So if I could have appearances first, please. Mr. Knight, you will need to be in front of a microphone.
Good morning. Andrew Knight and Crystal Weatherly appearing for the New Mexico Environment Department.
Thank you. And Mr. Woodward?
Good morning. Michael Woodward and Daniel Gustafson with Jennifer Hauer and Morgan Greer, who will be here a bit later on behalf of the Solido Isolation Mining Contractors.
Thank you. And let's see, Mr. Boutier. Okay. Any other counsel then?
Yep.
Yes, Mr. Hall.
Yeah, Miles Hall and Tom Ogg, counsel for the Department of Energy.
All right, thank you. I'm so used to calling on Mr. Boutier. It's not a habit. All righty. So let's see. I reviewed all the pleadings in the matter, and I did see two motions. If this past month or so had been different, I might have been able to actually write something up for the parties along these lines. Alternatively, I'm just going to speak to them this morning on the motion to dismiss, or in the alternative motion for summary judgment. I need to write up my recommendation to Deputy Secretary Roderick, and that recommendation will be to deny the motion to dismiss, and in the alternative motion for summary judgment, and then Mr. Roderick will have to address that in his final order. As to the other motion, this was a motion in limine directed at the GAO report, the GAR, and the BFNSB. I saw the motion and I saw the response from the department. I did not see a reply because the response was filed Friday. Would you like to offer a brief reply at this time? And in particular, I'd be looking for any indication that what appears to me to be indicia of reliability for these documents and reports to Congress that could be relied on in an administrative proceeding, that there's in fact not that indicia of reliability. And the other is whether what's implicated here is a substantial right. Thank you.
Thank you, Your Honor. With respect to the reliability of these documents, we think it's very clear that neither the GAO report or the DNFSB letter were prepared with an eye towards the compliance or non-compliance of the permittees, that being DOE and SIMCO, which is the acronym we use for the Salado Isolation Mining. And so these reports were prepared for completely different reasons than the review of the compliance for the permit. GAO is an arm of the federal Congress, and they look at assets of the federal government to determine the best way to describe it is the accounting life of an asset. And they look at how old is an asset, is it still make sense to spend money to continue to fix it, or should we think about using taxpayer money to replace it? And they don't look at safety. They don't look at any of the issues in a RCRA permit, Resource Conservation and Recovery Act, which is the law that covers the management of hazardous waste. The New Mexico authority over this facility is limited to the hazardous waste portion of the operations. It is a federal facility, a federal asset, and so GAO is not looking at that portion that New Mexico is regulating. They didn't even look at the permit, and they didn't even look at the assets that the NMED is now claiming were not operated in accordance with the rules and the permits of the NMED. So it may be reliable for the purpose it was written, but is not reliable for the purpose that the NMED is attempting to utilize. The DNFSB is a very similar situation. They're a sister agency, and they look at primarily nuclear safety, Defense Nuclear Facility Safety Board. And they are looking into issues pertaining to the management of nuclear materials. Again, they were not looking at the compliance with the NMED permit. And they were making recommendations on to be utilized when the United States Congress is making decisions about budgeting issues and whether the Department of Energy is going to get the necessary money to accomplish the mission of the WIP. The WIP is a very defined mission, and it's to take a set amount of transuranic waste that's in the United States and put it into this facility. And recognition that it's going to have to probably operate for years longer, maybe decades longer, in order to accomplish that mission. And so they're looking into the need to upgrade aging facilities to accomplish that mission. And again, it may be a reliable document for the purpose it's written, but it was not written for the purpose of determining compliance with the permit that the New Mexico Environment Department has issued. Now, with respect to substantial right, I really find it amazing that counsel would diminish the significance of this pleading. They said, well, we're not seeking fines, so it's not important. We beg to differ. The operational future of this facility depends on the compliance history. Compliance history is sacred. It's one that for a facility to be able to continue to operate under a hazardous waste permit must maintain as clean a compliance record as possible. The Hazardous Waste Act is very clear. The Secretary may deny a permit. The Secretary may deny a renewal of a permit. The Secretary may deny a request for a modification to a permit based upon a compliance history. If there is a violation of the act, a rule, or the permit, very specific, the secretary may deny that permit. So that is a very serious issue that my client is that's the reason we're here, is we adamantly maintain a violation of the permit did not occur, and we adequately maintain that neither one of these reports are evidence of a violation. And if it's the only information they're relying on, then there's no case to be had. But we're willing to go to hearing on this, and we're going to build as strong a record on this as possible if we go forward. And co-counsel for the Department of Energy may have something to add.
Yeah, I would just like, sorry, I would just like to add that with respect to the GAO report and the DNFSB letter, while the hearing officer may well be within her authority to take them as self-authenticating, they are as Mr. Woodward indicated, they are not or should not be admissible for use to prove the the matters that are asserted in the administrative compliance order. For among other reasons, it's impossible for us as the co-permittees to have any opportunity to question the authors of either of these reports, and I think that puts us at a significant disadvantage. With respect to the substantial interest or right, yeah, I would add that there are that the compliance and enforcement history of the waste isolation pilot plant is a substantial interest and substantial right. I mean, affects a substantial right in that our ability to, as an agency, as Department of Energy, to obtain funding and to continue permitted operations and to address any future enforcement actions is potentially compromised by a compilation of additional compliance history, and that's all I would really add to my colleague.
All right, thank you. Mr. Knight, I did have your response. I, I don't, unless you have something to add to it. This is definitely unusual in terms of the posture of the division proceeding on reports that they themselves did not prepare, for example. I would like to continue with the hearing and spend more time thinking about the substantial right here. Definitely familiar with the legal residuum rule and accustomed to thinking about that in the context of administrative hearings. So again, it's an unusual case, but I'd like to proceed with the hearing, and you can certainly have a continuing objection as to the admission of those documents if you'd like.
Yes, ma'am. We definitely have a continuing objection, and at the concern of being repetitive, when they are offered or when testimony is offered regarding these documents, we'd like the record to reflect that we are object to their entry, and for the reason of proving any violation of.
All right, no, I understand. Thank you. Is there anything else we need to talk about before we go to the witnesses?
Madam Hearing Officer.
That's all.
Yes. The first matter is regarding the admission of exhibits, and we would ask for a stipulation as to the admission of all exhibits that are not objected to.
Okay. Gentlemen, Mr. Woodward, Mr. Hall.
I apologize. I don't have your list of exhibits in front of me. I need to probably pull that.
Did you run?
Would council be agreeable to allow the entire permit to be become part of the record rather than just sections?
It is a very lengthy document, but I don't see any reason to object to that. I think we have the capacity uh, to put that into the record.
With the understanding of our standing objection to NMED Exhibit 3, the NMED Exhibit 4, and NMED Exhibit 5, based upon the fact that it was not disclosed in response to an ongoing discovery request, we will stipulate to the entry of the rest of the exhibits, with the understanding that we were going to ask for judicial notice of the entire permit. It's available electronically on the NMED website. And I think just to make the record complete, it'd be a good idea to have the entire permit in there.
All right, thank you. And Mr. Knight, do you stipulate to the respondents, I think it's 10 exhibit?
We do.
All righty. So the department's 10 exhibits are admitted, and the respondents' 10 exhibits are admitted. Your objections to the departments 3, 4, and 5 are noted, and you can certainly explore on cross-examination whatever you'd like to about those exhibits, regardless. Mr. Knight, anything else?
Yes. The second matter is that we would like to request that just for purposes of efficiency and time saving, that you allow our two witnesses to be cross-examined as a panel.
Okay. Mr. Woodward and Mr. Hall, this is something we often do, is to allow for panel cross-examination. It doesn't restrict you in any way. If you really need to pose a particular question to a particular witness, you can do that. Otherwise, the best witness to answer the question jumps in and answers. Mm-hmm.
Respectfully, we're going to object to this request. That they're really testifying on two different aspects of the administrative compliance order, and I have planned cross-examination to the specific witness, and I would prefer to be able to speak to the witness on the stand than to a panel.
Okay, and again, you can still do that. You can still say this question is for this witness. It's just that if the other witness has something to add, they can
Yeah,
jump in. You don't like that. Okay.
I've not been involved in a situation like that before. I would rather have one-on-one cross-examination with the witness.
All right. So we do typically do it in rulemaking rather than adjudication. But Mr. Hall?
I was just going to say that I think that we would have prepared in a completely different way for cross-examination if we had intended to do it as a panel. I think just in the interest of, you know, being an old lawyer, not wanting to change things around,
Right.
just keep it the normal way.
All righty. I won't swear in Mr. Bootsy to say that it really isn't that bad, but Mr. Knight, I don't want to take anyone by surprise, so let's do it the old way. Is there anything else?
Nothing further.
All righty. Let's. Are you going to do an opening statement?
Yes.
All right. Please go ahead.
First of all, I'd like to just say good morning to Madam Hearing Officer, our court reporter, the other parties, and our hearing clerks. Much like me, WHIP is getting old. Little known fact, I was actually there, physically present in the underground when some of the very first containers were in place. Back then, they were giving tours to students. I'm not sure if they're doing that anymore. I hadn't even started law school yet, and now I'm getting ready to retire. It's no secret that WHIP has been having a lot of trouble with their shafts and hoist systems lately. From our point of view, their own response to the DNFSB letter pretty much proves our case and demonstrates that everything we said in the ACO was correct. Clearly, there was a lot of work to be done to fix these problems. And the good news is that WHIP appears to have done a lot of that work over the past year or so, and has firm plans, apparently, to accomplish the rest. In hindsight, to the extent that the ACO had anything to do with getting this work started sooner or getting it done sooner, we are glad we issued it. Since this hearing was set so far out, almost a year since the ACO was issued, it looks now like the ACO has largely fulfilled its purpose, to the point that even if it were overturned today, it would not make that much of a difference. From what we can tell, the money has been allocated, the work is in progress, and nothing that happens here today is likely to change that timeline very much. In that sense, for us, this is a relatively low stakes hearing. The most we can win is getting the 5 documents listed in the ACO. The most we can lose is not getting those documents. Because that's all the ACO does. It requires 5 documents and makes 2 requests. There are $0 at stake here. Compliance with this ACO literally could have been an email from WHIP to us with those 5 documents attached. So what are we left with? Why are we here? It seems to come down to the principle of the thing. Can the state of New Mexico regulate the WHIP facility pursuant to our delegated RCRA authority or not? One thing that this matter has made clear is the need for alternatives to WHIP. Unfortunately, it will be a long time before that is a reality. Meanwhile, it is absolutely critical that as much of our nation's hazardous mixed waste as possible gets deep underground as soon as possible. And the only way that that is going to happen is if the WIP facility operates safely and efficiently over the rest of the current 10-year permit term. And with that, I would like to call my first witness,
Thank you.
unless opposing counsel would like to make their opening statement.
Would you like to do it now or reserve?
We'll reserve till before our direct case.
Thank you. Go ahead, Mr. Knight.
I would like to call J.D. Nance to come up here with me and present his testimony.
Mr. Nance, if you would please spell your first and last name.
Yes. First name John David. Last name Nance Nance.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead, Mr. Knight.
Good morning, Mr. Nance. Where are you employed?
Employed at the New Mexico Environment Department.
And what is your current position at NMED?
I am the Hazardous Waste Bureau Chief.
And how long have you been in your current position?
I have been in that position for 2 years now.
Will you please describe your duties as a bureau chief for the Hazardous Waste Bureau and who you supervise?
Yes. As a Hazardous Waste Bureau Chief, I primarily administer and oversee a number of different RCRA permits. These are about 19 permits. There are 19 permits that we oversee in the Bureau. My Bureau has 33 employees divided up between 4 different groups. We have a LANL permit group, a WIP permit group, a general permits group that handles all of the other facilities and Department of Defense facilities. And then we have a data and financial management group that does the financials and document retention policies, manages the library.
Madam Hearings Officer, I'm going to object to the witness having his computer open in front of him while he's testifying. It appears like he's reading his testimony.
We do that in our proceedings. He's allowed to read his testimony. Thank you. Go ahead.
With that, I do have the staff is specialized in what they're doing. I do highly rely on them for going through and reviewing different things, providing me information up to my position as the bureau chief, so I can be formally informed in making my decisions on behalf of the bureau.
Let's see. Would you please give a brief overview of your relevant educational background and training?
Yes. I'm a certified project management professional. I have 21 years of professional experience, spanning between 4 years as a legal assistant for an environmental, Native American environmental law firm. Also 15 years as a project manager, program manager, and a geologist in the consulting field, and then 2 years of experience in my current position as a RCRA regulator.
Please describe the WIP facility.
Yes. WIP is a hazardous waste facility currently operating under a RCRA permit that was issued by NMED. We are an authorizing, we're the authorizing a facilitator for that permit. The facility operates under that permit for the management of mixed waste, which is transuranic true waste that also has a hazardous waste component. So with the hazardous waste and the radiologic waste mixed together, that's what we can consider as mixed waste. With that, WIP does handle some of the most dangerous materials that we have in the state. And with that, the facility itself is one of the most complex and technical operational facilities we have. And with that has one of the most technical and complex RCRA permits that we issue within the state. Because of that extremely technical nature of the operations at WIP, the potential for widespread environmental harm in the event of a worst case scenario. Very low probability, but high risk situation, obviously. With that, the WIP permit is very specialized and technically robust to ensure that such a case does not happen.
And why exactly does NMED have regulatory authority over WIP?
So because a WIP handles transuranic mixed waste, the wastes are defined as hazardous waste, and then because of that, they fall under the RCRA regulations for managing hazardous waste. New Mexico is an authorized state by EPA to do so, so that gives us the authority to manage the facility and their operations or management of that hazardous waste or mixed waste.
And how does NMED implement that authority?
We implement that authority through our state authorization. EPA under 3006 has the authority to issue state authorization to states that can demonstrate that they meet the as stringent requirement as the federal regulations. Through the Hazardous Waste Act and our rules and regulations in the state, we have that threshold, and thus we have a state authorization to issue permits on behalf of EPA.
Can you please describe the WIP permit generally?
The WIP permit is a comprehensive regulatory document. It governs the facility's ability to receive, manage, handle, and dispose of these mixed wastes. The permit that is issued is a treatment, storage, and disposal permit. And basically it functions for the storage and disposal components that is performed at the site. However, this permit has many specialized requirements, clauses and exceptions that are written into the permit, which makes it a very complex and unique permit that we issue here in New Mexico. Structurally, the permit is organized into distinct parts that establish general facility standards, operational conditions for surface and underground storage, also waste characterization requirements, and extensive environmental monitoring plans. The permit also contains a series of detailed attachments that contain specific operational procedures. It contains emergency plans, closure protocols, and waste analysis plans. Together, these components define a very strict, legally binding document that gives boundaries from everything from container inspection to organics monitoring to even the exact volumetric limits that the underground disposal can operate with.
Excuse me, Madam Hearing Officer. I'd like to re-urge my objection to the reading of this testimony. We filed a discovery request on the Hazardous Waste Bureau, and we asked for any documents that are going to be referred to at hearing. It appears there's a written document on his computer. We've not been provided. And at a minimum, I think we should be provided that document so we could read along while the testimony is being provided. It seems like, again, they're preparing documents that are not being provided to us in accordance with the discovery request.
All right. I'm going to overrule that objection or deny the request. We simply don't prohibit from prepared testimony or notes to remind the witnesses of what they've agreed to talk about when they're being examined by the counsel that they work closely with at the agency. We just don't prohibit it here and wouldn't necessarily think of it as discoverable. Go ahead, Mr. Knight and Mr. Nance.
Can you please describe the specific permit requirements at issue in this ACO as shown in our exhibits 7 through 10?
Yes. The specific permit requirements listed in the ACO concerns permit part 1, section 1.7.7, which requires the permittees to maintain the facility and associated equipment and structures in good repair in the protection of human health and the environment. Permit part 2, section 2.10.1 requires the permittees to maintain the facility and equipment specified in the contingency plan that's also presented in permit attachment D. Permit attachment E, which is to identify the issues that are seen so they can make corrective action on those and ensure safe operations of the facility. And last, permit attachment A2-A1. Within that, it states WIP's hoist systems are designated to withstand dynamic forces and withstand a design basis earthquake of 0.1 G's, gravitationals, peak ground acceleration.
And what is the Hazardous Waste Bureau's experience with WIP's compliance history?
Yes. Outside of the 2014 incident, once the facility was back up and running, looking back 10 years, they've had almost yearly violations that have been identified through inspections. Those are comprised of mishandled documentation around labeling of containers, labeling of oil drums, and most recently there was an ACO for excess combustibles that were located in the underground, and poorly packaged universal waste lamps. So dealing with
This testimony is not relevant to this proceeding, and I believe he's actually mischaracterizing some of the information that talking about. And so we can go back and try to relitigate some of the previous ACO, but I don't believe that that is relevant to whether the ACO is provable in terms of the alleged violations.
Mr. Knight, I'm not sure I remember the other ACO being mentioned in the ACO in question. How is this relevant?
Madam Hearing Officer, I will just say that it is my belief that a facility's compliance history is always relevant in an ACO hearing. But with that being said, we are happy to just move on.
Hi, if you would, please.
Mr. Nance, has the Bureau ever issued a compliance order based on third-party documents?
Yes. In 2014, following that incident, NMED issued an ACO based on utilizing information from an accident investigation board report to ensure compliance with the RCRA permit. The details of that report, the AIB report, and the expertise of the selected board that comprised and wrote that report. We utilized those to provide evidence of noncompliance to the RCRA permit. Enforcement and corrective actions were put in place to ensure events like what had happened wouldn't happen in the future.
And what is that AIB report that you just referred to?
Yes, it's a report that was prepared by an appointed accident investigation board. For this particular report, the board was appointed by the Deputy Assistant Secretary of Safety, Security, and Quality Programs under the U.S. Department of Energy and in the Office of Environmental Management. The board was appointed to perform an accident investigation to prepare an investigation report in accordance with the DOD accident investigation procedures.
And you were referring to the Department of Energy, not the Department of Defense, right?
Correct. Yes, the U.S. Department of Energy.
And how was this AIB report used in that compliance action?
The information contained in the report and identified root causes and secondary causes that led to the incident. Those were reviewed and compared to the regulatory requirements within the RCRA permit. Where we were identified non-compliance with that permit, requirements were constructed around that and put in place to ensure that any incidents like that wouldn't happen again.
How did the Bureau become aware of the GAO report?
On June 24th, we received a Google alert. So that indicated that the GAO report was issued. So my staff, they monitor outlets and look for reports for information just so we can understand what's going on with the facility.
And can you please describe the GAO report?
Madam Hearing Officer, I'm just going to re-urge the objection again regarding the GAO report and its discussion. I'm also going to object to this witness's attempting to provide an interpretation of the GAO report. I don't believe he's been properly established as an expert on the GAO or what they do, and therefore unable to render an opinion on that report.
All right, so you have a continuing objection as to the admissibility of the GAO report. Mr. Knight, would you lay a little bit of a foundation with Mr. Nance?
Madam Hearing Officer, if I could just respond. I believe Mr. Nance testified as to his qualifications and educational background, and he is a professional in the area of RCRA regulation. He is a bureau chief in our department, and it is my argument that that qualifies him to describe. I'm not asking him to interpret. I'm not just asking him to describe in general terms this GAO report, which is on the subject of a RCRA permitted facility that he oversees in his position as a hazardous waste bureau chief for the state of New Mexico.
And is that the sort of report he would ordinarily be reviewing or relying upon in his job?
We can ask him as Mr. Nance, is the GAO report the sort of report that you would normally be reading and relying on to perform your duties as a hazardous waste bureau chief?
Yes, depending on what the report might be reporting on, the topics of it, and how it might relate to information finding or overseeing and regulating a facility.
So, Mr. Nance, can you please describe, in general terms, the GAO report?
Yes, the GAO reported on the website's uh, the GAO report on their assessment of DOE's contractor oversight at WIB. The GAO did report on WIP's critical infrastructure on those assets, and basically stating that several assets were identified as being in substandard condition, especially while the facility is expected to operate for many years to decades longer than what was originally anticipated. GAO did recommend improving contractor oversight and also data reliability for assessing those assets, and also ensuring that the site contractor is performing long-term infrastructure planning to make sure that infrastructure is being maintained in a proper fashion moving forward, given the longevity of WIP's mission.
And what information in the GAO report led to the Bureau's concern with WIP?
Information in the report did raise concerns for us, the Bureau, regarding compliance with the permit's proper operation and maintenance condition. With the report finding that critical infrastructure, the data used for maintenance and decisions, that report found that data to be somewhat unreliable, and DOE had not adequately developed timelines for corrective actions. The report did state that over half of the critical assets were in substandard or inadequate condition as of their reporting of their data, which was 2023. With these findings, for us, it was suggesting that the facility had potential deficiencies in maintaining those necessary systems for the overall WIP mission, and also maintaining those systems for performance and compliance with permit requirements, given the facility's anticipated extended lifetime.
And how did the Bureau come to know about the DNFSB letter?
As I stated, my Bureau does monitor different outlets for reports. So we had received a notice on that. We also were reviewing and saw a posting on their website. And then we also had an outside source that had notified us that a letter had been issued.
Can you please, again, in general terms, describe the DNFSB letter?
Yeah, it was a June 18, 2025 DNFSB letter. It was issued discussing WIP's aging shafts and escapeway hoists, and that they posed increasing reliability concerns for the emergency evacuation of underground workers. The letter specifically identified significant age-related degradation of the salt handling shaft and associated hoist and conveyance system with that shaft. They also concluded that long recognized infrastructure problems had not been addressed in a timely manner, and expressed concerns about the effectiveness of WIP's aging infrastructure management program. The board did request that DOE provide a plan and timeline for reducing risks associated with the degraded escapeway hoists, and evaluate whether existing infrastructure management processes are adequate to support WIP's mission.
And what information in the DNFSB letter led to the Bureau's concern with WHIP?
It did raise concerns regarding compliance with the permits, proper operation and maintenance condition. The board found that the salt handling shaft had experienced significant age-related degradation, and that all three hoists that are relied upon for emergency egress are more than 30 years old and are increasingly difficult to maintain. With these findings, we felt it suggests potential deficiencies in maintaining critical safety infrastructure, as well as a possible weakness in maintenance planning, the corrective action implementation, and the infrastructure management.
And what were the next steps that the Bureau took?
So the Bureau, my staff, we met and we proposed issuing a notice of violation without fines, requesting a compliance schedule, and ensure that these maintenance problems were going to be addressed in a timely fashion.
Now, moving on, what is the relationship between the Hazardous Waste Bureau and the Compliance and Enforcement Bureau?
Yes, so the CED, Compliance and Enforcement Division, within it, the CEB, Compliance Enforcement Bureau. It was created for a number of reasons, including separating the compliance and enforcement function away from from my bureau, Hazardous Waste Bureau, and other bureaus. So, or like my bureau can focus on the permitting requirements of a facility, and then the enforcement side can look at compliance enforcement and handle that side of it. So it separates, still kind of keeps those powers together, but separates them into different groups. This was a major reorganization that took place last summer, July 2025. And with that, a number of hazardous waste employees did transfer over to that new division. This did happen right when this ACO was being prepared, was being determined, prepared, and issued. And we were still in the process of figuring out the working relationship between the Hazardous Waste Bureau and the Compliance Enforcement Bureau.
Now, did you personally read the GAO report and the DNFSB letter before recommending the notice of violation to the Compliance and Enforcement Bureau?
No, I did not.
And as a bureau chief, do you have the time or the ability to read every supporting document for every enforcement recommendation that your bureau makes?
No, I do not.
Do you have a competent staff to brief you on the details of the supporting documents to help you make enforcement recommendations?
Yes, yes, I do. I rely heavily on my staff to provide me information that has been researched so I can make informed decisions.
And do you review certain details on an as-needed basis?
Yes, depending on what the topics are, I will review certain parts of different documents and reports and look at different information, again, based on an as-need basis.
How did your staff present this enforcement concern and recommendation to you?
Yes, they brought it to my attention. We had an office meeting. We meet regularly on different issues, on planned inspections, work that's coming in. And during that, they brought it to my attention. We discussed the issues and the points that were raised in the GAO report. And then we, from that discussion, we determined a recommendation.
And what are the procedures for transferring an enforcement recommendation to the Compliance and Enforcement Bureau?
Currently, An issue is identified in the permitting group that then is elevated to myself as the bureau chief. Once we determine it needs to move forward, we'll prepare a briefing paper, and then I will then elevate that up to senior leadership and also Office of General Counsel for further considerations. Once that is elevated up, it will then get transferred over to the Compliance Enforcement Bureau for their handling and determination of how they're going to move forward with that.
Are these the same procedures that were in place in June of 2025?
No, they weren't. During that time, we were still working to stand up that bureau and then also work through how we were going to interact with our functions.
So what were the procedures you followed for transferring this recommendation for an NOV to the Compliance Enforcement Bureau in June of 2025?
Yes, I elevated the issue up to the Director of Compliance and Enforcement, Mr. Bruce Basil, and also to Office of General Counsel. At that time, it was then the NOV that we recommended was sent over to Dr. Sachs.
And how did Bruce Basil respond?
The direction received was to move the NOV that we had recommended into Administrative Compliance Order into an ACO. We were then instructed to move the information from the NOV into the ACO structure.
And are you aware of whether NMED senior management weighed in on that decision?
At the time, I was not directly aware if senior leadership weighed in, but assume that that communication did happen with Bruce Basil up to senior leadership.
In your mind, was it proper for, say, the secretary to weigh in on this decision of whether to elevate the NOV to an ACO?
Yes, I do.
And why do you believe that was appropriate?
The Hazardous Waste Act defines the program director as the Secretary of the Environment. As the director, he's authorized to implement and enforce the state authorized program. The Secretary has delegated authorities down to the Hazardous Waste Bureau and also through the Compliance Enforcement Division and also to myself as the Hazardous Waste Bureau Chief. But ultimately, any decisions that are made on behalf of NMED is also on behalf of the Secretary as the director of the state authorized agency.
And how does state RCRA authorization work?
Under Section 3006, EPA can give state authorization to administer the program on behalf of EPA. New Mexico does have this authorization through our establishment of the Hazardous Waste Act, also the agency's framework, rules and regulations that are met as stringent as the federal regulations are. With that, NMED is granted state authorization to implement the RCRA program on behalf of EPA. This does give the Secretary of the Environment the authority to implement and enforce federal and state laws and regulations at that state level.
So who drafted the ACO?
So the draft was performed by my staff in Hazardous Waste Bureau under direction from Bruce Basil to move the NOV that we recommended into an ACO structure. So we provided that. As we were going into that new organizational structure, at the time I was not aware of who was handling that, but my staff did put that information into the ACO.
And who reviewed the ACO before it was issued?
It was sent back to Bruce Basil and ultimately landed with Dr. Staggs for his review.
Okay. And finally, what what relevant information to the ACO have you become aware of since the ACO was issued?
Since it was issued, I did attend a conference, the Waste Management Conference out in Phoenix, Arizona, where several presentations were provided showing infrastructure improvements being performed, additional monies that were being provided for those improvements, and addressing certain matters. Also, in discussing with Steelworkers Union, they let it be known that several shafts are currently down for different reasons, and recently with the salt shaft and other shafts being down for multiple reasons, the underground is not currently operational because of not having 2 operational emergency egresses for workers.
And Madam Hearing Officer, I believe that completes Mr. Nance's direct testimony, and he is available for questions.
Thank you very much, Mr. Knight and Mr. Nance. Mr. Woodward, are you going to begin the questioning? I would like to take a break at around 10:30 if you would just count on identifying a good place.
Okay, thank you. Good morning, Mr. Nance.
Good morning.
I believe we met before when we took your deposition. Is that correct?
Correct.
Are you an engineer?
No, sir.
Have you received any training in mine safety?
No, sir.
Have you personally inspected the whip underground and the condition of the hoist?
No.
Now, in your deposition, you testified that in preparation for the deposition, you reviewed the ACO, but I learned today you did not read you did not read the GAO report.
What timing?
Before issuing the ACO, you did not read the GAO.
I had a briefing on it and looked at a few sections, but I did not read the report entirely, no.
And you did not read the letter from the DNFSB.
In the same way as I was briefed on the GAO report, I read only a few sections. Did not read it entirely, no.
Other than taking the McCoy's record training in February of 26, what other training have you had in RECRA?
Working experience through consulting, my 15 years of experience doing environmental consulting under the RCRA framework.
Do you agree that the primary purpose of RECRA is protection of human health and the environment?
Yes.
Do you agree that RECRA doesn't authorize the state to make business decisions on behalf of permittees?
Yes, I agree.
Have you ever worked in a mining facility?
No, I have not.
Are you familiar with the regulations from the Mining Safety and Health Administration?
Just a brief understanding of them, but not directly within them.
Have you ever worked with the regulations of the Mining Safety and Health Administration?
Directly with them?
Yes.
No, sir.
Have you ever received training on any of the Mine Safety and Health Administration regulations?
No, sir.
Have you ever had training or experience with mine hoisting equipment?
Not mine hoisting equipment, no.
You've never been to the underground of the whip?
Not in the ground, just the above ground.
Other than learning from a conference that the underground is currently not operational, can you accurately describe the operational status of the hoist systems?
In what manner?
Is the reason hoist or reason why the underground's not operational?
Specifics, honestly, are hearsay, but we're uh, understood that there was kind of an owl's nest that was in one shaft, not allowing it to be operational. Others that were likely down for numerous reasons, either for repairs or for maintenance.
And is that speculation on your part?
It is.
So you don't have personal knowledge?
No, sir.
Can you accurately describe the procedures in place for operating the hoist at the whip?
No, I cannot.
So you referenced the GAO report and the DNFSB letter causing concerns about compliance. Do you have any personal information or evidence of noncompliance?
Outside of publicly available information, such as the GAO report and the DNFSB report.
Well, you said they created concerns about noncompliance. So
Yes.
I'm asking if you have any personal knowledge or information of that shows actual noncompliance.
Personally, no.
Are you aware of any instance where the hoist procedures at the whip were not followed?
No, I do not.
Do you have personal knowledge that the hoist were ever operated in a condition that were unsafe to human health?
Not direct knowledge, no.
So I assume you do not have personal knowledge about the hoist systems posing any threat to the environment.
Personal knowledge, no.
Do you know which hoist the owls are allegedly nesting in?
Again, speculation. I believe it is shaft 5, but I'm not certain.
You know if shaft 5 has a hoist?
Yes. I think so.
Do you have personal knowledge on how often the hoists are inspected?
Personal knowledge, no, I do not.
You agree that the RECRA permit issued by the NMED requires inspection of the hoist?
Yes.
Have you reviewed the maintenance logs for the hoist systems at the whip?
Not personally, no.
So, can you tell me what the purpose of your testimony is?
Giving an overview of what the Bureau, what our findings were, what we were looking at, based on the information that we had gathered, and based on the evaluation of that information against potential violations to the RCRA permit.
So would you agree then you're testifying on the process by which the administrative compliance order is developed and issued?
We, I'm testifying on that process of information gathering, evaluation, and recommendations that we provided over to the Compliance Enforcement Bureau.
What information did the Hazardous Waste Bureau gather other than the GAO report or the DNFSB letter?
Those were the primary sources.
Was there any other information developed?
Not that I recall.
Have you since read the GAO report since after issuance of the administrative compliance order?
Yes.
But you didn't see it important to read the report prior to issuance of the ACO?
In my capacity as bureau chief, I am getting briefed on, like I stated, 19 different facilities with a lot of different competing information. I rely heavily on my staff to give me briefings and updates on their recommendations.
Do you agree with me that you do not have personal knowledge on whether there was a non-compliance at the WIP facility as alleged in the administrative compliance order?
Personal knowledge is physically seeing it on myself, or from information gathering that potentially could have. I'm just trying to make sure I'm clear on the question.
I'm trying to clarify whether you're testifying that non-compliances actually occurred at the WIP as alleged in the administrative compliance.
I'm testifying that we, again, gathered information and made recommendations based on that over to the Compliance Enforcement Bureau for further evaluation.
So you're not testifying that non-compliances happened?
We identified potential for, and then as we had the separation of the different bureaus, the other bureau went forward with a further evaluation and issuance of compliance.
So you agree with me, identifying the potential for the non-compliance is not identifying a non-compliance.
Yes, we were looking at the potential for, based on our review and our interpretations of what the permit says versus the information that we have.
So the GAO report and the DNFSB letter raised concerns,
Yes.
but you agree they are not evidence of non-compliance.
Excuse me. It raised concerns. Those two entities, because they were reporting on similar and overlapping, not the same, but overlapping issues focused around the infrastructure, maintenance, and safety of the shafts and the hoist systems. That information, as we feel that they are independent, reliable third-party auditors in their capacity, we felt that that was a reliable source to have concern that it was in violation of the permit.
Let's go back and review it again.
Okay.
I believe you testified that the report, GAO report, and the DNFSB letter caused concerns of non-compliance.
Yes.
So do you agree then that they're not evidence of non-compliance?
I'm going to object. That calls for a legal conclusion, and it's been asked and answered.
All right. It sounds as though it might be asking for a legal conclusion. To the extent that Mr. Nance can speak to it as a regulator, he can offer an answer. But Mr. Nance, we know you're not a lawyer.
Thank you. From a regulator standpoint, our position is to look at information that we can gather, because and then take that information and evaluate it against permit conditions. As a regulator, we ask questions. We ask for documentation and justification around the information that we found or lack of information. Given that we saw this information from these third-party entities that we feel are reliable sources for specific things that they're focused on, our interpretations of their information against the RCRA permit, again, raised concern based on the evidence that we saw in those reports that they reported on. With that, we recommended a notice of violation to provide information, asking for information from the facility on how that facility is compliant or going to be compliant based on the information gathered in those reports.
You agree that the NMED has authority to gather additional information when a concern is raised about compliance with a RCRA facility?
Yes, we do.
Did your staff take any steps to gather any additional information to either verify or to verify the GAO report or the DNFSB?
No, we did not.
Did your staff make any request to the WIP for any of the operational logs on the hoist?
No, not my staff.
Did your staff make any effort to request additional information about inspections and maintenance of the hoist?
Not that I'm aware of. I don't think we did.
So it's you agree then that the recommendation to make the notice of violation was based solely on the GAO report and the DNFSB letter?
Yes.
At the time the ACO was issued, you cannot accurately describe the operational status of the hoist systems, can you?
No.
Nor can you accurately describe any preventative maintenance that's been performed on the hoist 5 years prior to the issuance of the ACO.
No, sir.
And you cannot personally describe the procedures in place for operating the hoist.
No, sir.
Can you identify any instance when WIP hoist procedures were not followed in accordance with the RCRA permit?
I cannot recall that off the top of my head. No, sir.
Can you personally describe the qualifications of personnel who inspect the hoist?
Personnel that are with the facility and the contractor?
Yes.
No.
I believe you already stated this, but you've not reviewed any of the maintenance logs on the hoist systems at the WIP.
No, not personally.
You do agree that those maintenance logs are available to the NMED inspectors?
Yes.
Do you recall what chapter of the RCRA regulations the WIP facility falls under?
I think it's subpart X. I can't recall off the top of my head.
What is a subpart X facility under RCRA?
I'd have to go back and review. I don't recall those off the top of my head, sir.
So you agree with me that Part 264 of the RCRA regulations are divided into the types of management units for management of hazardous waste?
I'd have to review.
So you'd have to review the regulations to confirm if WIP is a subpart X facility?
Probably to have to review, but I'm pretty certain that it is of subpart X.
Do you know if subpart X of part 264 of the record regulations contains any prescriptive requirements for the operation of mine hoist?
I don't believe it does, but again, I'd have to review. I believe there are requirements for um, uh, facilities being in operable condition, but I don't think it specifically calls out mining hoists.
Do you recall whether subpart X has any prescriptive requirements, or is it a performance-based regulation?
I'd have to review.
Does the Hazardous Waste Bureau have any inspection staff?
Currently very limited, and our inspection staff is not geared towards inspection of facilities against RCRA regulations. The amount of inspection staff I currently have are geared towards inspection of other facilities per the WIP requirements in their permit, or other generators bringing waste to WIP.
Does the RCRA inspection team fall under the Compliance and Enforcement Division?
Yes, they do.
So your division or bureau doesn't have any responsibility for RCRA inspections at the WIP?
Correct. Our function is on the permitting side and reviewing permit conditions.
As I understand your testimony, it was really based upon timing that this enforcement action was initiated in the Hazardous Waste Bureau.
Correct.
Do you recall if any of the RCRA inspection reports of the WIP were reviewed prior to the issuance of the ACO?
Or past violations, or
For past inspections? I mean, I'm not assuming violations, but
okay,
there are regular inspections conducted by the NMED of the WIP facility. Is that correct?
correct.
And the regular RCRA inspections of the WIP conducted by NMED.
Yes.
And I was just asking if there were any reviews of those RCRA inspections prior to your bureau recommending the notice of violation.
Not a formal review. There was some conversations, but not a formal review of the reports.
You would agree with me that prior to initiating an enforcement action, it would be normal process to review the agency's own inspection records of the RCRA facility.
Yes.
But that didn't happen in this case.
Correct. We were, again, transferring into a different organization. And so recommendations I had sent up to Mr. Basil for review.
Do you have any personal knowledge about the policies and procedures at the WIP for maintaining escape hoist?
No, I do not.
Do you have any personal knowledge about periodic inspections and preventive maintenance occurring at the hoist at the WIP?
I know it's performed, but that's about it.
I'm sorry?
I know that it's performed, but that's it.
So you don't know the criteria upon which the inspections are conducted?
No, sir.
This might be a good opportunity to take a break.
All right, thank you for uh, speaking to that. Let's take 15 minutes. Come back at well, after 10:40. Let's come back from the break, please. Do we have
Our, our witnesses
Mr.
will be here in just a moment.
All righty, we'll wait for Mr. Nance.
Madam Hearings Officer, will we be planning to take a midday break?
Yes, for lunch. There are a number of fine restaurants in the area.
What time would you break?
Well, I like to break at a kind of a natural place. So if we finish with Mr. Nance and maybe at the direct of Dr. Staggs, and it seems to be about lunchtime, then we would do that.
I don't think we'll be finished with Mr. Nance.
Before
But
noon?
yeah, it's going to be close. We're going to be here a while.
All righty. We're back after our break. Mr. Woodward.
Thank you. Mr. Nance, you don't have any knowledge about whether the Mining Safety Health Administration has issued a notice of violation regarding maintenance of the escapeway hoist whip, do you?
I don't believe they have, no.
So you do know that they've not issued a notice of violation?
As stated earlier, I attended that conference in March, and I believe one of the presentations stated they had no violations, or there were some minimal issues.
Did anyone from the Hazardous Waste Bureau contact, and I'll use the acronym MSHA, which stands for the Mining Safety Health Administration, prior to issuance or prior to recommendation of notice of violation?
No, we did not.
Do you know if anybody from the Hazardous Waste Bureau reviewed any investigation reports or investigation summaries from MSHA prior to recommending the notice of violation?
I don't believe so.
Do you agree that the RCRA permit issued by the Hazardous Waste Bureau incorporates criteria from MSHA into the inspections of the hoist of the whip?
Could you repeat the question?
Do you agree that the RCRA permit incorporates MSHA criteria into the inspection requirements of the hoist at the whip?
I believe there's components of that, yes.
Do you have the permit provisions that were entered into the record in front of you?
I can pull them up.
Let's look at table E-1. And I believe that's NMED Exhibit 9. What's the first item listed in that table?
Facility transfer vehicle, is that correct?
I obviously need to look at it. Are you looking at table E-1?
I think
My apologies. This was table E or attachment E, but you're looking for E-1.
Correct.
I am looking at NMED exhibit 9.
Well, in your exhibit list, it says table E-1 only. So I'm specifically referring to table E-1 entitled Inspection Schedule / Procedure.
Oh, that's
I got it.
different than what is listed as NMED exhibit 9 on the docket. But are you referring to something other than NMED exhibit 9?
No, no, it says table E-1 only in your exhibit list. I don't think it matters. We've agreed to put the entire permit in, but what I'm referring to is table E-1 inspection schedule / procedure. And what's the first item listed for inspection?
Air intake shaft hoist.
So what does this table indicate?
It indicates the items that are subject for inspection, and those procedures, also the responsible organization responsible for those inspections, the frequency, and then the procedures on which those inspections are being performed.
And it also identifies the inspection criteria, correct?
Correct.
And if we go over and read that block beneath procedure number inspection criteria for the air intake shaft hoist, that incorporates the requirements of MSHA, does it not?
Yes, it does.
And there are several footnotes there that further define. So would you agree then that these are the permit requirements for inspection of that particular hoist?
Yes.
Did you look at any of these criteria or these requirements prior to recommending a notice of violation?
Myself personally, no.
Did anybody in the Hazardous Waste Bureau look at any of these inspection criteria or requirements prior to recommending the notice of violation?
I'm not aware. I don't believe my staff looked at those. No,
You don't believe they did?
I don't believe they did.
But these are the specific criteria listed in the RECLA permit that the ACO alleges have been violated.
Yes.
But you didn't look at these criteria.
Not that I'm aware of. I don't think we did.
Did NMED send anyone to the WIP to investigate the concerns that were raised in the GAO report?
I don't believe we did. I don't believe we did. Pardon my memory, I vaguely remember that there was discussions with the inspection group to look at certain aspects, but I'm not aware if they did go to the facility and look.
You agree that there's no information presented in the administrative compliance order that indicates that anybody from the NMED investigated the concerns raised in the GAO report?
Correct.
Did the Hazardous Waste Bureau review any information pertaining to the infrastructure of the WIP before issuing the ACO, other than the GAO report and the DNFSB letter?
Out of my bureau, no.
Did the Hazardous Waste Bureau employ any experts in mining safety to investigate the concerns raised in the GAO report or the DNFSB letter?
No.
Did the Hazardous Waste Bureau contact either DOE or SEMCO to discuss the GAO report before issuing the ACO?
No.
Does the NMED ever contact a regulated record facility to give them an opportunity to discuss concerns before formal enforcement?
It's case by case.
But sometimes that opportunity is provided.
Sometimes, yes.
Did you have any involvement with the process of issuing the ACO after making the recommendation for a notice of violation?
I had some conversations around, you know, thoughts of moving forward, path of moving forward. But as far as review and determination of that, no.
Who prepared the testimony on your laptop that you're reading from today?
I did, and had consultation with my WIP group on certain specifics.
Did you work with your legal counsel in preparing those answers?
Yes, I did.
Are you receiving any messages on your computer now while we're talking?
No, I'm not.
Would you mind closing it?
Sure.
Did the NMED take any steps to verify the information in the GAO report prior to issuing the ACO?
As far as with a facility or with GAO or just in general?
Verifying, did the NMED take any steps to verify the information contained in the GAO?
Outside of reviewing the report, no.
Did the NMED take any steps to verify the information in the DNFSB letter prior to issuance of the ACO?
Again, from my bureau standpoint, no, we did not. Outside of reviewing the letter,
So nobody from the Hazardous Waste Bureau spoke to anybody at the GAO about the GAO report?
no, not after insurance, no.
Did anybody from the Hazardous Waste Bureau speak to any of the authors of the DNFSB letter?
Not after it was issued, no.
You're not aware of any infrastructure concerns that were identified in any record compliance inspection conducted before or after the ACO was issued?
And no, I'm not.
You agree the GAO report does not mention the record permit issued by the NMED?
Correct, it does not.
You agree that the GAO report does not mention any of the inspection criteria listed in the record permit for the hoist?
Correct.
You agree the GAO report does not say anything about safety.
The GAO report does not.
You agree the GAO report is addressed to a congressional committee.
Yes.
Do you know if anybody from the GAO report actually went into the underground of the WIP to assess the condition of the hoist?
Based on the report, it looked like they did a document review, but I don't think they physically went into the underground, no.
Do you know if anybody from the GAO looked at the operator's logs for the hoist when they did their document review?
I can't comment on if they did that or not. I'm not aware.
So really, you don't know what information was relied on in preparation of the GAO.
Outside of the summary that was provided in the report, no.
The GAO report says they did not, and does not say anything about inspecting the hoist, does it?
No, it does not.
And the GAO report doesn't say anything about them inspecting the infrastructure.
No.
And the same goes with the DNFSB letter. It doesn't say anything anywhere in the letter about anybody from the DNFSB inspecting the hoist.
I don't believe it does.
Do you know if anybody from the DNFSB inspected the hoist?
I'm not aware if they did or not.
Do you know if anybody from the DNFSB had any expertise in mine safety?
I can't say on their expertise on their level.
Do you know if anybody from the DNFSB had training or expertise in hoist maintenance?
I'm not aware of that, no.
Did you review DOE's response to the DNFSB letter before recommending the notice of violation?
No, I did not, no.
So you're unfamiliar with the maintenance program and processes to monitor structure systems, components, and regular maintenance at the WIP?
Overall, generally, or?
Specific to the hoist.
Oh, not specifically, no.
So authority to regulate hazardous waste facilities comes from both state and federal law, yes?
Correct.
And the state of New Mexico implements record authority both under the New Mexico Hazardous Waste Act and the Federal Resource Conservation and Recovery Act.
Correct.
And the authority to implement the federal portion of this program is granted through the EPA, correct?
Correct.
That's the Environmental Protection Agency. States. Do you know if the GAO has been granted any regulatory authority over hazardous waste facilities?
They have not.
Do you know if the DNFSB has any regulatory authority over hazardous waste facilities?
No, they do not.
Do you know if the GAO has any permitting authority over hazardous waste facilities?
They do not.
Does the DNFSB have any permitting authority over hazardous waste?
No, they do not.
So it's the New Mexico Environment Department that has permitting authority of hazardous waste facilities located in New Mexico.
Correct.
And it's the New Mexico Environment Department who has hazardous waste enforcement authority over hazardous waste facilities located in New Mexico.
Yes.
Are you aware of any prior NMED enforcement action against a RCRA permitted facility being based on a GAO report?
Not off the top of my head, but again, we do look at public information in evaluating if there are any violations to a specific RCRA permit.
If a RCRA hazardous waste facility in New Mexico receives, or if the NMED receives an anonymous complaint on a RCRA hazardous waste facility, would NMED act solely on an anonymous complaint to bring an enforcement action?
We would, on an anonymous complaint, we would definitely investigate it and look into it.
And what do you mean investigate and look into it?
Based on the source, based on what information is provided and what information that we have in front of us for a facility or a location.
What type of investigation would you do?
We would look at the allegation that was provided by the source, look at how it would be in violation of that permit, and then look at the facility itself to see if there's credible information that we can have to request or look at if there was a violation or if there was any concern for further information gathering or for issuing a violation.
Would you conduct an investigation of the facility?
Depending on what the allegation is, yes.
Would you take a look at the records of the facility to see if there's any information to verify the nature of the complaint?
Depending on the nature of the complaint, yes, we would look at that.
Are you aware of receiving complaints on facilities and investigating the basis of those complaints for a RCRA facility in New Mexico?
Please restate the question again.
Is there a RCRA facility in New Mexico in which you've received information about a possible violation in which you followed up with additional investigation to verify that information?
We've had a number of generator sites that fall under the RCRA regulations. I can't recall specifically a site that a RCRA permitted facility where that has occurred, but based on information received, we would definitely investigate.
And you investigate to make sure that you have adequate information to prove up the allegation of a violation, correct?
We would look at the information in front of us. If we feel it was credible information, then yes, we would follow through.
You mentioned in your testimony about attending a waste management symposium in Phoenix, I believe it was.
Correct.
When was that?
I believe it was, I can't recall the exact dates, but it was one of the first weeks of March of this year.
And did you meet somebody from the DNFSB and talk to them about the letter they issued to WIP?
Yes, yes, I did.
And is it true they told you that the letter was issued to drive federal funding?
Correct.
Did he mention to you that the DNFSB letter looked into record compliance?
And he didn't look into record compliance. No,
So that was not the purpose of the letter.
correct.
Let's look at administrative compliance order. Ask you to open your computer again.
Okay. No worries. Okay.
So to be clear, these are assertions that Simcoe and the DOE have violated their permit, correct?
Yes.
So this is an enforcement action alleging violations.
Yes.
And violation number 1 maintains that the permittees have failed to maintain the facility in good repair.
Yes.
Is the phrase good repair defined?
Specifically, good repair, I don't think is specifically defined, but it in a regulatory framework, it is considered um, uh, operation and maintenance, up to date, or safe operation and continual operation of whatever that facility is operating.
And so the permit provision 1.7.7 says to, and I'm paraphrasing, but it's to maintain the facility to ensure compliance with the permit.
Correct.
You agree with me that the main goal of the permit is protection of human health?
Yes.
There's nothing about the permit that mandates that a certain volume of waste go into the underground on a certain time period.
Within the permit, there's provisions for prioritization of certain wastes, but I don't think in the current permit there's any set time frames that I can recall.
So in terms of inspection and maintenance, you agree that 1.7.7 sets out the goal, but it doesn't describe the details of how to get to that goal.
Correct.
You have to look at the permit in a whole.
Correct.
So wouldn't you agree then that you would have to show other provisions of the permit that have been violated in order to say that this particular permit provision has not been complied with?
If the information that, from a regulator standpoint, if the information is showing that a facility is not meeting that criteria in the general sense, I would, from again, from a regulator standpoint, I would want to see the facility to provide information contrary to the statement that they're not meeting um, that specific criteria.
But the Hazardous Waste Bureau never asked permittees for that information, did they?
Correct.
And the Hazardous Waste Bureau never looked at available information to show that there's been proper maintenance and care in operating the facility.
At the time, no.
So I think we've agreed the record does not regulate business decisions for record facilities.
Correct, not business decisions.
It's to ensure the facility operates in a manner that's protective of human health and
Yes, yes, and yes.
And I think you agree. My experience has told me that regulators would much rather see a facility operating safe, if that means operating slower, than operating faster in an unsafe condition.
Ultimately, we'd want to see the safety of the workers and also affected people in and out.
That's the priority. And that's the regulatory basis for record, isn't it?
Yes.
Does it say anywhere in RECRA or the implementing regulations or the Hazardous Waste Act or the permit that having old equipment is a violation?
No, not specifically to old equipment.
So you agree that with proper procedures, protocols, preventive maintenance, that old equipment can be operated safely?
With proper maintenance, as long as potential risks for failure or endangerment of human health and environment is mitigated.
What was that last word?
Mitigated.
Mitigated. Because you can't remove all risk.
Yeah.
Is potential for failure a violation under the record regulations or the permit?
If there's a heightened risk in operation, we definitely want to look at that. That would raise concern.
That was not my question, though. Again, I hear the word concern, but I'm asking about, is it a violation? Is a potential failure a violation?
Potential failure. Excuse the um, the analogy, but if someone's standing on a train track and they get out of the way of a train before it hits them, there would be concern that that action could potentially cause harm. From a regulator standpoint, if the evaluation shows a heightened risk, that would be something that would be looked into and investigated. To answer your question, if something did not happen, ideally, I mean, if black and white would not be a violation, but from a regulator standpoint, looking at facility operations and operational efficiencies and safety concerns, potential adds a level of risk that would need to be looked at and adjudicated if needed.
Everything has a potential failure, doesn't it?
At some level.
So how do you measure what is that heightened risk? Do the regulations identify it?
Not specifically.
Mines are dangerous, aren't they?
They are.
So there's a potential risk in a mine,
Correct.
but operating a mine is not illegal per se.
No, no, it's not.
So we agree that a potential failure is not a violation.
A potential failure before it occurs would not be a violation. Adding in really quick, just for context on my response, grew up in the area. Most of my family worked in mines. My dad was in a mine back in the late 80s, working on a belt, potash. Okay, we're dealing with potash. Lockout, tagout procedures were not being followed correctly. He thought something was up. He was doing his work on a machine. Another gentleman came over and turned on said machine, and cable that ran the conveyor pulled open, pulled in all of its slack, whipped around, caught my dad in the leg. Fortunately, he was okay. A lot of surgery, got everything back together, but that pretty much put him on disability retirement. With that mindset, a potential issue has risk. And if, as a regulator, we can identify those and try and mitigate those in the best way possible, as you said, there are risks in everything we do, especially in mining. With the WIP facility, not only is it an active mine with competent people mining and working the facility, it also has a hazardous waste and a mixed waste radioactive component that heightens the risk that we as regulators want to overlook, because a cable that causes a knee surgery is probably highly unlikely, but of several low risk concern to something like that happening and causing a radioactive waste release. I know I'm off topic here, but
No, I think you're right on topic, and we're going to dissect it a bit.
yeah.
First off, I'm sorry about your dad's accident. That's unfortunate. But I think you started out that description about not being tagged in and tagged out. Right? Now that's a violation, right?
Correct.
There's processes and procedures that have to be followed.
Correct.
And if you don't follow the processes and procedures, that's a violation.
Correct.
But the potential that there's going to be a failure is not the violation.
From that perspective, no, it is not a violation.
The potash mine is covered by the same regulations, mining regulations, as the WIP, correct?
Correct.
So we know that there are intensive inspection requirements, pre-operational inspection requirements.
Yes.
There's intensive preventive maintenance requirements.
Correct.
There's intensive corrective action when issues are identified.
Correct.
If you don't do all of those requirements, that's a violation. But the potential for failure is not the violation. The failure was caused, you agree, the failure was caused potentially by the processes and procedures and the maintenance not being conducted.
Correct.
And in this instance, the regulator, Hazardous Waste Bureau, has chosen not to look at the very processes, procedures required under its own permit. You agree?
A potash mine doesn't fall under RCRA as handling hazardous waste.
I was shifting on.
I know.
I was shifting to you.
Yes.
And
okay.
so you agree with me. We looked at table E-1. There's very specific inspection criteria specified for the WIP. for the hoist
Mhm.
in the record permit.
Yes,
Those are the requirements to try and minimize the potential failure from happening, correct?
from a mining perspective, yes.
It is a mine,
It is a mine. It is
and it's
also a hazardous waste repository.
okay. Do we know if hazardous waste is being carried on the air intake shaft?
No, it is not.
So it's serving the purposes like it would in any mine, correct?
When it's functional, yes.
Do you know of any other heightened requirements that a permittee is supposed to comply with other than the very requirements that are put into the record permit?
Those are their requirements.
Did you identify any violations of those requirements in the record permit?
Other than the information we had previously discussed.
Information received from the GAO report.
Correct, for the
It did
longevity of the facility.
longevity of the facility. Which permit provision did that violate?
It's looking at the potential risks that are looking at the information from the independent entities and looking at potential risks and concerns around applicability to maintaining the full facility from a hazardous waste repository standpoint. With that, our relief was a schedule on how it was going to be addressed. So,
From a safety perspective or a reliability perspective?
yes.
No, which?
Oh.
Which safety requirements of the permit were violated? You can't identify one, can you?
No, sir.
The GAO report is discussing reliability, isn't it?
Correct.
Does the NMED regulate reliability?
We have regulations to make sure that the facility itself, as a hazardous waste management facility as a whole, operates for that function and for the safety of human health and environment.
Safety and the human health and environment.
Mhm. Oh,
Was that a question?
It was a question.
yes.
So the administrative compliance order is not alleging that the WIP is not properly inspected its hoist.
Correct.
And the administrative compliance order is not alleging that it is not properly engaged in corrective action with the hoist pursuant to findings of those inspections.
For that was the reason we asked for the schedule, was to provide evidence showing compliance with that corrective action in a timely manner.
But you didn't ask for that evidence before issuing the ACO.
Correct.
So you didn't have evidence that the WIP has not properly engaged in corrective action to correct any issues identified by the inspection.
No, nor did we have evidence that they were in compliance with.
Who has the burden of proof to show a non-compliance?
From a regulator standpoint, we ask questions of the facility to show burden of proof that they are in compliance.
But we've already discussed the administrative compliance order is alleging that violations occurred.
Yes,
Which other than the GAO report or the DNFSB letter, you have no other evidence that violations occurred.
from the Hazard Waste Bureau, no.
From any other bureau of the NMED?
I'm not aware of that.
Okay. Let's look at violation number 2 of the ACO. This is a allegation that DOE and SIMCO have failed to properly maintain the evacuation equipment as required by the permit, correct?
Correct.
And this allegation of noncompliance is based upon the letter from the DNFSB.
Correct.
You're not aware of any corrective action to the escapeway hoist that has not been taken, are you?
Madam Hearing Officer, could we ask, I'd ask that we rephrase the question with the double negative?
It was a double negative.
I'm asking in a leading portion. If you'd rather I ask it this way, say, are you aware of any corrective action, required corrective action on the escapeway hoist that has not been taken?
Specifically, I can't recall.
It's a no.
You know,
So you don't have personal knowledge about what, if any, equipment needs to be replaced on the escapeway hoist?
personally, no.
Are you aware of the MSHA requirements pertaining to maintaining escapeway routes from a mine?
Not the specific ones, no.
Is it your opinion that the replacement of this escapeway hoist is the only way to maintain compliance?
Depending on the identified issues from a competent engineer, um, it, it could lead to replacement depending on what those issues are, but can't speak to those.
So again, you don't know if there was a competent engineer who's done an analysis of the maintenance on the escapeway hoist.
Not to my knowledge.
Let's look at violation 3. This alleged violation is alleging that, or this violation is alleging that Simcoe and DOE have failed to address identified equipment deficiency. Does the NMED contend that Simcoe or DOE have failed to conduct inspections on the facilities?
Not on the inspections, no.
Can you personally describe the exact equipment that is alleged to be degraded?
Not the exact equipment, no.
Can you describe with your personal knowledge what equipment has that DOE and Simcoe have failed to timely repair?
Outside of the salt shaft and 3 other hoist systems that were identified in the DNFSB report, no.
Is there a requirement in the record regulations or the permit on how quickly a piece of equipment has to be repaired when it's taken out of service?
No.
If equipment is repaired, equipment that's been taken out of service is repaired prior to being put back into service, don't you agree that would be timely?
Yes.
Did the Hazardous Waste Bureau or any other bureau of NMED ever raise concerns with permittees about failure to timely implement corrective action on infrastructure?
No.
Do you recall any NMED inspection report identifying a failure at the WIP to implement corrective action on equipment?
No, not that I recall.
Do you have requisite training and experience to talk about a design basis earthquake?
Not specific. I have general training in geology, but not in depth on structural integrity engineering.
Does the NMED have any evidence that the hoist systems can no longer withstand the design basis earthquake?
No. However, we again had concerns because the evaluation was done many years ago. And given the information that we had received in the 2 GAO and DNFSB reports, we felt that a revisit or recertification would be beneficial.
Is there any requirement in the record regulations? And when I say record regulations, I mean as implemented by the NMED. So is there any requirement in the record regulations or the record permit for a requalification or recertification?
Not specifically.
Did the Hazardous Waste Bureau or other bureau of the NMED ever ask for a requalification or recertification of the hoist system?
No.
Does the Hazardous Waste Bureau have any evidence, or does the NMED have any evidence that the hoist systems can no longer meet the design basis?
Outside of information from the DNFSB report, no.
Did the DNFSB report make any finding about the ability of the hoist systems to withstand the design basis earthquake?
Um, it made note that degradation had occurred, specifically with the salt shaft, that was causing infrastructure repair. So from the Bureau standpoint, we looked at that and felt changes structurally might have occurred based on salt defamation, based on years of use. And with those changes outside of the original design build of the shaft, there might be concerns that structurally it may or may not be able to withstand that type of gravitational force.
Did the DNFSB letter make any mention of the design basis?
No.
Of the hoist system?
No, sir.
Did the Hazardous Waste Bureau make any technical analysis of the hoist ability to meet the design basis?
No.
What I hear are concerns and might. I'm asking, does the Hazardous Waste Bureau have any evidence that the hoist cannot meet the design basis?
We did not do that evaluation. No.
And when we look at table E-1, and we look at the procedure number and inspection criteria, what is the first item that inspectors are supposed to look at for an air intake shaft?
Inspecting for deterioration.
Deterioration. Did Hazardous Waste Bureau ever look at the inspection logs to see if there was a failure to look for deterioration in the hoist?
No, sir.
Well, if we were to flip back to the footnotes on table E-1, and if you will agree that there's a footnote B on deterioration.
Yes.
Could you flip to footnote B and read that for the record, please?
Yes. Footnote B is deterioration includes obvious visible cracks, erosion, salt buildup, damage, erosion, loose or missing parts, malfunctions, and structural deterioration.
Would you agree that these would all be criteria you would want to look at to determine whether a facility could still meet its original design basis?
Yes.
Did the Hazardous Waste Bureau make any inquiry as to whether any of the inspections had identified deficiencies in any of these criteria?
No.
You're aware that there has been seismic activity in southern New Mexico.
Yes.
Do you have any evidence that the hoisting systems have been impacted as a result of that seismic activity?
No, I do not.
Do you know what FIMS stands for?
Not off the top of my head. I think it was an information management system.
I'm sorry, I couldn't hear you.
Don't have the exact acronym, but I think it is an information management system.
Federal Infrastructure Management System.
Yes.
Do you have any direct experience with FIMS?
I do not.
Is FIMS mentioned anywhere in the record permit for WIP?
I don't recall.
So you've had some training and experience with RECRA. Do you recall if FIMS is required anywhere under the RECRA regulations?
It is not.
Is FIMS in any way required by the New Mexico Hazardous Waste Act?
No, it is not.
Do you know what FIMS is?
It's an asset management system used by the federal, I believe, Department of Energy for asset tracking.
Do you know for sure?
That's my understanding.
You don't know who DOE reports to through FIMS? Through FIMS.
Not specifically.
Is there any allegation that DOE or Simcoe have ever submitted inaccurate information to NMED in an annual report?
Not to NMED.
FIMS is not a report to the NMED, correct?
No.
And there is no specific record permit provision that requires DOE to maintain the FIMS database.
Not specific to FIMS, no.
And there's no one from NMED who has verified the accuracy or inaccuracy of the FIMS data.
Not that I can recall, no.
If we can go a little bit past 12, I might be able to finish up this morning. If you want to stop at 12, it might be a good time to stop.
Oh, are you fine, Mr. Knight and Mr. Nance? All right, we can go a little past 12. It's all right. We'll still take an hour.
Why did you recommend a notice of violation rather than an administrative compliance order?
Our perspective was we were wanting to issue the violation to retrieve that information with the compliance schedule and the pieces, how WIP was going to respond in kind to what the information we found in those two letters, GAO and DNFSB. Also, we felt there was no reason to have any type of monetary fine, as we were looking for a schedule and a plan on how a compliance schedule on how the facility was going to address or is currently addressing the concerns that were raised.
Why was there a recommendation for no penalty?
We felt that the information provided would show that the facility was moving forward, or at least give the information showing the schedule of how the facility is going to move forward with that.
Before the responsibilities were transferred from the Hazardous Waste Bureau to the Compliance Enforcement Bureau, did you have any experience with RCRA enforcement?
Yes, for about a year, I had record enforcement in my bureau.
Are there any internal criteria for the agency to look at to determine whether to recommend penalties or not?
Yes, we would look at the violation itself, the severity of the violation, how it folds in. There's a chart. My former program manager for the compliance and technical assistance program that used to be under me would go through that evaluation.
Was there any evaluation on the severity of these alleged violations in the ACO?
Prior to issuing the ACO? Or,
Yes.
I'm not sure if that was performed. Again, we submitted the violation, notice violation up. CED did the evaluation, gave us the recommendations to change it to an ACO.
Do you recall when your bureau transmitted the draft notice of violation?
The date?
Mm-hmm.
It was in July, I believe, of 2025.
Do you recall how long of a time it was before the ACO was issued after you transmitted the draft notice of violation?
I believe it was about 2 weeks. I can't, in that time frame.
About a week, maybe?
Within there, yes.
How much time transpired when you transmitted the notice of violation to when you received the direction to move forward with the ACO rather than a notice of violation?
I don't know the specific time, but it was a couple days.
Maybe a day? Is that possible?
It is possible. Possible.
Do you know, were you involved in any conversations about the severity of the violations and whether penalties should be sought?
I had a verbal conversation over why we were not pursuing penalty, and pretty much kind of reasserted my recommendation that we feel that there's no reason to have a penalty in this issue. It's more of, from a permitting standpoint, just getting documentation and a schedule showing further compliance moving forward.
Is an administrative compliance order the only way you can get the information you were seeking?
No, there's other ways.
Who directed you to move forward with an ACO rather than an NOB?
Mr. Bruce Basil.
Did you receive any explanation for the change from an NOB to an ACO?
Other than that was been the process and procedures we were starting to move towards with all facilities, was looking at more at administrative compliance orders, and also that the elevating it to that level would be more of a legal binding interaction to get the data that we were looking for.
Did you ever have any communications with anyone about verifying information or collecting information to verify that violations of the permit had occurred?
Not that I recall.
So the goal was to get a legally binding document issued on the WIP.
The goal was to obtain a compliance schedule around the issues that were brought forth that we saw in the GAO report and also in the DNFSB report.
And you wanted that compliance schedule to be contained in a legally binding document.
We were looking to make sure that a compliance schedule would be followed through in that manner.
Do you, is it your testimony that the GAO report and the DNFSB letters are evidence of violation?
Once again, I'll renew my objection that calls for a legal conclusion.
I seem to remember that you asked this question about an hour and a half ago, and I directed him to answer as a regulator, and I think he gave you the best answer he could as a regulator. Where?
That mean no.
I'm sorry?
Does that mean he can answer the question?
No, I think he's already answered the
Okay.
question some time ago.
That's all the questions I have at this
All right, thank you, Mr. Woodward. Mr. Hall?
Yeah, I'll be brief. Good afternoon, or almost afternoon. Good to see you again. I just had a couple of things that I wanted to follow up on. You mentioned the 2014 administrative compliance order, or the compliance order relating to the events that took place in February 2014. Have you read that administrative compliance order dated February 27 of 2014?
No, I have not.
Have you read the AIB report regarding the radiological release event dated April 2015?
No, I have not.
Have you read the AIB report dated March 2014 regarding the Salt Hall truck fire incident?
No,
Would you agree with me that March 2014 and April 2015 are after February 27, 2014?
yes,
Okay. So the, would you agree with me that the administrative compliance order that you have not read was not based on the AIB reports? Could not have been. They weren't issued.
in that sense, on the issued report, probably not. No.
Do you know what evidence was cited in the administrative compliance order? What information was cited as the basis for issuance of the administrative compliance order?
No, not specifically.
Okay. Um, are you familiar with the Hazardous Waste Bureau's penalty policy in 2017?
From 2017? Not specifically, no.
Is that penalty policy still in effect? You know?
We do have a penalty policy. I can't speak if it was the same one from 2017.
Do you know whether the current penalty policy, whether it's the 2017 policy or some more recent one, takes into account in calculation of penalty a history of compliance?
Yes,
Okay. And would you agree that Hazardous Waste Bureau may apply an upward adjustment to penalties for a history of non-compliance?
yes.
Is an administrative compliance order like the administrative compliance order that was issued last year we're currently in this proceeding? Is that the type of non-compliance that would be included in a compliance history for evaluation under this penalty policy?
It would be considered, yes.
I think that's all I have.
All right, thank you. Mr. Knight, will there be redirect?
There will not.
Great. There's no reason not to excuse Mr. Nance. Thank you very much, Mr. Nance. Let's take an hour. It's exactly 12. We can come back at 1. Food trucks across the street are good for those of you who've traveled to Santa Fe. And then we'll hear from Dr. Staggs. Thank you. Let's come back from the lunch break, please. When we broke, we had completed the testimony of Mr. Nance. We now turn to Dr. Staggs. Would you spell your first and last name, please?
Yes, Kyle, Kyle, Staggs, Staggs.
And do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead and swear.
Good afternoon, Dr. Staggs. Where are you currently employed?
I'm currently employed at the New Mexico Environment Department.
And what is your current position at NMED?
I am the Chief of the Resource Protection, Compliance and Enforcement Bureau under the Compliance and Enforcement Division.
How long have you been in your position?
I've been in this position since July 1 of 2025.
Will you please describe your qualifications?
Yes, I hold a PhD in chemical engineering and a Bachelor of Science in chemical engineering. The PhD is from Arizona State University and the bachelor's is from University of New Mexico. I also spent approximately 13 months in Los Alamos, so I learned a little bit more about their interactions with WIP during that time, and I spent the time between that and working at NMED in the teaching, primarily finishing grad school and teaching of mechanical engineering, especially materials science.
Can you please describe your duties as the NMED Bureau Chief for the Compliance and Enforcement Bureau?
Yes, in my current role, I oversee compliance and enforcement for the NMED bureaus under the Resource Protection Division. That would be the Hazardous Waste Bureau, the Petroleum Storage Tank Bureau, and the Resource Recovery Bureau, formerly known as the Solid Waste Bureau. My current compliance and assistance technical team is responsible for the compliance and enforcement under the Hazardous Waste Act, as well as enforcement of RCRA regulations for all the regulated entities for the state.
How do you normally receive enforcement cases?
Most often, my staff will bring me information regarding the status of a facility that has been inspected, or they'll bring me some sort of information about a facility, and we will from there make decisions. They will make recommendations on the appropriate mechanism of enforcement, and we will review that evidence that they bring to me, and from there we will craft the appropriate enforcement mechanism and send it up our chain for approval.
How did this matter come to your attention?
I was first consulted when this was being, I believe, reformatted from an NOV to an ACO. So I was initially consulted on that particular document, and I didn't get to review it until after it had been drafted and run through OGC for approvals.
What initial steps did you take once this matter came to you?
I did some additional research based on the summary of the GAO report and the DNFSB letter that were provided to me, and I had done some investigation to see if there was anything else going on at the facility, anything else being reported in the about WIP, and there were a few hoist-related incidents that I had seen some news stories on at the time, and that helped to sort of add some credibility to what I was hearing about as being identified in the GAO report and the DNFSB letter.
Do you rely on the news story in your decision to issue the ACO?
No, the news stories simply reinforced a narrative that seemed to have some validity to me.
What did you rely on?
I relied on the contents of the GAO report and the DNFSB letter, more specifically the summary of program staff and what they had provided me in summary.
As a regulator, is it your opinion that NMED has the authority to issue a compliance order based on any information received?
Yes, and the reasoning for this is fairly simple. Often we identify violations and they may not be what would be considered severe or egregious violations. And depending on the severity of, as I believe was identified earlier, there's a distinction in our penalty policies for what is more or less major or minor in the penalty policy, and we'll weigh those accordingly. So there's options for an entity to respond and say, no, these actually aren't real violations. Here's the documentation to demonstrate that.
And where does that authority come from?
This comes from the Hazardous Waste Act, specifically when it opens discussing whether on the basis of any information the Secretary determines that any person, as defined in that statute, has violated or is violating or threatens to violate any requirement of the Hazardous Waste Act, any rule adopted and promulgated pursuant to that act, or any condition of a permit issued pursuant to that act. It gives the Secretary the express authority to issue compliance orders or even pursue civil penalties.
What information did the Bureau's program staff provide when you received the draft ACO?
They provided me, I believe, in an email, a copy of the GAO report and the DNFSB letter.
And did you read the GAO report and the DNFSB letter at that time?
I did not read them in full at that time. I did review the executive summaries that were on the first page of each, and that summarized the content consistent with the reports I was given by program staff.
And have you read the GAO report and the DNFSB letter since issuing the ACO?
Yes.
And did you find any information that would alter your decision to issue the ACO?
No, I did not. In fact, rereading them reinforced that the issuance of the ACO seemed objectively to be the correct decision.
As a bureau chief, do you find that you're able to read every supporting document for every enforcement action?
No, that would be impractical, as the total volume of documentation that I deal with is in the many thousands of documents. It's not something that's tenable, so there ends up being a reliance on the program staff to help bring summaries and provide the necessary support information and participate in the kind of internal quality controls that we do.
Are you able to attend every facility inspection with the department's inspector?
No, I am not. There are several thousand facilities that we oversee, so that would be impractical.
In your current role, have you been on any facility inspections along with the department's inspectors?
Yes, I have. Specifically, I try to prioritize some of the federal facilities inspections, as they tend to be of many more sites, and they tend to be much more intricate in their nature.
Have you ever been on an inspection at WIP?
No, I have not. My staff recently completed an inspection at WIP, and I was greatly disappointed I was not able to attend because of schedule conflicts.
Did NMED find any potential violations on that recent inspection at WIP?
They did not on the recent inspection. There was a separate and unrelated records request review that had happened somewhere in between the issuance of the ACO and this particular inspection. And upon that review, they did find some violations that were identified. Specifically, there were a couple items related to, I think in the inspection logs, there were some switches replaced that didn't have any kind of prior identification of a malfunction. There were some other electrical system notes. There was an electrical issue with one of the emergency communication systems for a couple different periods of time. And there was the auxiliary fire truck was down for a period of time. I want to say about 3 weeks or so, that fire truck was substituted, but the substitute didn't have all of the equipment transferred. So most notably, it was lacking a first aid kit.
Have those alleged or have those violations been resolved?
Yes, they were resolved within the time frame of the same records that were being reviewed by my staff. And in accordance with the sort of normal process, we reviewed the information, determined that there wasn't a penalty warranted as a result of those, and we issued what is called a notice of violation and return to compliance. We call it an NOV RTC, which means that the entity has addressed the concerns that we identified within the time frame, either of the inspection or within a reasonable time frame following the inspection.
Do you often make enforcement decisions based on the recommendations of department staff?
Yes, that is part of the normal process. Their primary job is to bring information to me so that can help make decisions on the level of severity and the priority of the enforcement for that particular entity.
Did you issue this ACO with violations that were not explicitly cross-checked with the supporting evidence provided by your program staff?
Yes, I did.
Why did you do that?
This was a circumstance where this is one of the first ACOs that I had seen presented, and there had been decisions made on issuing the ACO at the leadership levels above me, and the information that I saw in the executive summaries for both the GAO report and the DNFSB letter were sufficient, in my view, to warrant issuing the ACO under the understanding that the receiving entity has the clear opportunity, either with an ACO to request a hearing or simply provide the documentation that the violations are invalid or unwanted or have already been addressed.
Approximately how many facilities does your Bureau oversee for compliance and enforcement?
Between all three sections, the number is somewhere between, I believe, 3,600 and 3,700 facilities. I would have to look through multiple databases to confirm an exact number.
Thank you. Okay, I'm going to ask you some questions about the contents of the ACO. How many violations does the ACO contain?
There are 5 violations.
And what does violation 1 allege?
Simply stated, it's a failure to maintain the facility infrastructure in good repair.
And what information did NMED use to support the allegation?
We primarily relied on the information in the GAO report as pointing to the likelihood of a violation of the permit condition 1.7.7, specifically detailing the 37 million in deferred maintenance that had not been done. That called into question whether or not the facilities were being maintained as they ought to have been.
And what does violation number 2 allege?
A failure to maintain the evacuation equipment as required by the permit.
And what information did NMED use to support that allegation?
This was supported by the DNFSB letter, specifically as it was focusing on the shafts and hoists as at WIP, and the letter identified those as being or identified rather that the WIP management, the WIP on-site management had identified all hoists as being obsolescent, and the permit section 1.7.7 speaks to keeping the facilities and systems and the auxiliary facilities and systems in a state of good repair.
What does violation number 3 allege?
Failure to address identified equipment deficiencies.
And what information did NMED use to support that allegation?
This was primarily from the GAO report, where it was identifying that more than half of the mission critical infrastructure was either substandard or inadequate per their evaluation.
And what does violation number 4 allege?
The failure to maintain equipment integrity required for design basis earthquakes.
And what information did NMED use to support that allegation?
This was primarily through the GAO report identifying the 37 million in deferred infrastructure maintenance and the more than half of the mission critical assets in substandard or inadequate condition. There were also identified in the DNFSB letter significant material condition issues based on age, referring to the hoists.
What does violation number 5 allege?
Inaccurate and outdated infrastructure condition data.
And what information did NMED use to support the allegation?
The GAO report identified that DOE had repeatedly found errors in the data, finding what they termed unreliable values for the infrastructure.
Was there a penalty issued with this ACO?
No, there was not.
Why not?
The internal conversations were, I'll say, influenced to a degree both by JD and myself to not include penalties, as this did not seem to pose an immediate hazard to human health. This rather looked to be identifying a longer term issue that we wanted to work on getting some resolution to.
Does the ACO require any corrective actions?
Yes, it does.
How many corrective actions are listed in the ACO?
There are 6 listed along with 2 ongoing requests.
Can you please describe the first requirement and the reasoning for that requirement?
A corrective action schedule for repair or replacement of mission critical infrastructure, and the reasoning for this is NMED expects, if there is ongoing procurement, ongoing maintenance, and any ongoing work, there would be schedules, project management documents, there should be a documentation trail, and we would expect those should be readily available if work is ongoing.
Can you please describe the second requirement and the reasoning for that requirement?
Yes, the equipment repair and maintenance milestones, or what entities were going to be responsible for those, and we asked that those be presented in a table format for the simplicity of reporting.
Please describe the third requirement and the reasoning for that requirement.
A description of how WIP will ensure the evacuation and hoisting equipment will be maintained in good repair. NMED wants to understand specifically what is being done for maintenance of those critical infrastructures so that miners can be safely evacuated in emergencies.
And can you please describe the fourth requirement and the reasoning for that requirement?
A plan to evaluate the structural integrity and compliance of hoist systems with design basis event requirements. The reasoning is that the permit attachment A2 was specifying the 0.1 G acceleration for the design basis earthquake. To put that into context, that's equivalent to a moderate earthquake where things hanging objects would be swaying back and forth. So it's not a severe category of earthquake, but it would be enough to notice, and we want to make sure as NMED that workers can be safely evacuated under those kinds of events.
Can you please describe the fifth requirement and the reasoning for that requirement?
Yes, documentation demonstrating that inspection findings are being used to inform and drive timely corrective action for maintenance. And again, any ongoing work would have records, would have schedules, would have deliverables, responsible parties, contracts, documents that should be readily available.
Can you please describe the sixth requirement and the reasoning for that requirement?
A revised process or procedure that ensures infrastructure condition data in FIMS, the Federal Infrastructure Management System, or other relevant tracking systems are accurate. And the reasoning is if DOE finds at times unreliable data from WIP, then we want to make sure that the data we are getting is also reliable as NMED.
Thank you. So for the two requests that are in the ACO, can you please describe the first request and the reasoning for that request?
Yes, NMED requests to be included in the ongoing correspondence for any future responses to the GAO report and the DNFSB letter. The GAO report and DNFSB letter looked for the very same kind of feedback and information that we sought in this ACO, and we're looking to see that the maintenance is being done.
Will you please describe the second request and the reasoning for that request?
Yes, NMED requests periodic status updates on DOE's implementation of the 3 recommendations from the GAO report because NMED is also interested in seeing the documented timelines, improved FIMS data collection, and the way that they will incentivize the long-term infrastructure planning.
In your professional opinion, are any of these requirements or requests unreasonable?
No, I would say they are not unreasonable. I would say they are quite reasonable, assuming the work is ongoing and the documentation is available.
Has anyone from WIP or DOE or SIMCO provided NMED with any of the requested information in the corrective actions of the ACO?
No, not to my knowledge.
Are you aware of any possible corrective action taken by WIP or SIMCO DOE related to the ACO since it was issued?
Yes, based on my attendance of the Waste Management Conference that was in early March, there were a couple WIP specific presentations that were given that I was able to attend. One was a general status update of WIP and kind of identifying generally where they were in the mission. The second was very specifically focused on what they presented as safety-minded infrastructure upgrades. They presented a number of items related both to the air shaft and to the replacement of one of their main hoist motors. So they presented a lot of useful information. There were additionally some panel discussions, and there was another presentation given that was the WIP Capital Asset and Operating Facility Project Management session. SIMCO's procurements, since I have seen those more recently, had a few different postings in requests for proposal. One of their RFPs was closed, it looked to be February 2026, including complete replacement of 2 new hoist systems and the electrical infrastructure upgrades for the hoist systems. Deliverables included the very exact type of information planning documents that the GAO, the DNFSB, and NMED had asked for. An earlier RFP that closed, I believe, September 2025 was seeking electrical system upgrades and controller upgrades specifically for the hoists. And there was an even earlier RFP I noted that closed, I believe, July of 24 that seeks to extend the life of the waste shaft hoist specifically. So the totality of the RFPs are consistent with the story that's told by the DNFSB letter, the GAO report, and the NMED ACO asking for documents.
Based on that information, is NMED willing to consider any of the corrective actions resolved for purposes of the ACO?
Yes, NMED would be. The kind of information that is presented publicly since the issuance of this ACO meets most of the criteria to eliminate the violations. The only one that would not be potentially would be the design basis earthquake requirement of the permit. So I would hope that will be included in their design criteria for what seem to be the ongoing RFPs for the hoists.
Thank you, Dr. Madam Hearing Officer, I have no further questions, and we have already addressed the exhibits.
Thank you. Mr. Woodward, would you by any chance have questions for Dr. Stein?
Thank you, I do. Did I hear you right? Y'all are willing to withdraw the ACO?
If the information is provided in accordance with the ACO, we would be, yes.
Did we break?
Yes, sure.
All right. If you'd like to just come find us when you have had your conversation, I won't put a deadline on it.
Thank you.
Happy to leave the room. Luis, would you mute the room so that, oh, thank you. Let's come back from the break, please. Ms. Weatherly or Mr. Woodward, would you like to fill me in?
It was discussions were unsuccessful.
Oops, all righty. Let's go back to the questioning of Dr. Staggs.
We need to wait for our court reporter.
Oh, thank you. Ready? Okay, thank you. Go ahead, Mr. Woodward.
Thank you. Dr. Staggs, when did you start with the NMED?
Started with NMED in November of 2024.
And what was your initial position with NMED?
I was in the Air Quality Bureau Compliance and Enforcement section.
And are you the first chief of the Compliance and Enforcement Bureau?
Yes, I was the first one hired into the entire Compliance and Enforcement Division after the director and deputy director were placed.
How long had you been the bureau chief before signing the ACO?
Less than 30 days or about there.
What all did you review before signing the ACO?
I had reviewed the summary that was given to me by the program staff regarding the GAO report and the DNFSB letter.
Excuse me for the interruption. I have a request from the platform that you be closer to the mic if your mic is on. Yeah? Okay.
Yes, it
Thank
is.
you.
Apologies. Can you repeat the question?
What all did you review before signing the ACO?
I reviewed the summaries provided by the program staff of the GAO report and the DNFSB letter, and had briefly reviewed the executive summary on the front page of both documents.
So the program staff were Compliance and Enforcement Bureau staff, or were these Hazardous Waste Bureau staff?
These were Hazardous Waste Bureau staff.
And the summaries you reviewed that they prepared were of the GAO report and the DNSFB letter.
Correct.
And you did not read the GAO report or the DNSFB letter?
Not in full, no, only the executive summaries.
And what other information did you review before signing the ACO?
I had reviewed other information from news stories of a series of events related to cables snapping at the WIP site, and apparently those were reported to result in stop work orders, or at least some of them did.
Do you know the details behind the series of events you described?
I only have the 30,000 foot view provided by the reporting agencies. So I don't have a specific detail, no.
And when you're talking about reporting agencies, who are you talking?
news outlets. I think a number of the stories were posted to a few locations. I think the original stories may have been in the Carlsbad Current Argus, and they were, I believe, reposted or summarized on other sites. I think I came across it on one of the Yahoo reposts, or maybe it was USA Today. I don't recall exactly.
Do you recall the time period of when this incident or incidents occurred?
The reports were toward the end of 2023. I wouldn't be able to give you specific dates, but that's what was reported.
Do you know which shaft the incident occurred in?
I don't recall.
Do you know if the incident occurred in any of the shafts or hoists that are the subject of the ACO?
No, I don't know offhand.
Did the NMED staff provide any additional information about the incidents that you read about from a Google search?
No, they did not.
Okay, so you reviewed on summaries of the GAO report and the DNSFB report prepared by hazardous waste staff. Did the Hazardous Waste Bureau staff include any other information in those summaries besides information included in the GAO report or DNSFB?
No, I don't believe so.
So the summaries you read were solely from the GAO report and the DNSFB letter.
That is what I recall, yes.
Okay, so you relied on the summaries and you relied on a newspaper article about an incident. What other information did you rely on before signing the ACO?
I'll first clarify the news report was not a primary source of information and not one I relied on in relation to the ACO. It simply lent some credibility to the types of information that was being summarized to me regarding the GAO report and the DNFSB letter. To answer the question, the GAO report and the DNFSB letter were the primary documents relied on for this particular enforcement action.
You say primary, are there secondary reports or information?
No, I mean primary as in the sources of importance that were used. There were no secondary resources consulted for the purposes of generating or sending out this ACO.
So they're the sole information that provide the basis.
Yes, that would be a fair characterization.
Help me understand how the newspaper article lent some credibility to the information obtained from the GAO report.
I was aware that the GAO report and the GAO in general is not a direct oversight group. So this is a source that provides information, but they don't function in a regulatory capacity. So the news story demonstrated that there may be some incidents, again, which having not witnessed directly, having not directly verified, being related to hoists and cables snapping across multiple incidents, it made the report showing that, especially the contents of the DNFSB letter specifically, since that seemed to focus on the hoists and the status of that infrastructure. It suggested that there may be reason to treat that as more than just a letter suggesting there may be more funding needed or something like that. There may be some kind of underlying safety issue that's going on if there are other events happening consistent with that report.
Did you make any effort to connect what you read about in the newspaper to determine whether there was any relevance or connection to the operating hoist in the mine?
From what I observed, they weren't posted on the accidents page that WIP has, at least not as far as I'm aware. So they may not have been considered to be severe. I would consider a bucket crashing a couple thousand feet to the mine floor alarming, at least. But I don't know that I was not there to observe that, and I did not see a clear accident report related to that. So I can only weigh that as hearsay in my enforcement decisions.
If you received information that the incident had absolutely nothing to do with the hoist within the mine, would that change your opinion on whether it linked credibility to the GAO reports?
It would not change my mind on the credibility of the GAO report or the DNFSB letter. I would be interested to know out of curiosity.
Have you had any RECRA specific training other than the 5-day McCoy and Associates course?
No, I have not.
And your training from McCoy occurred about 7 months before you signed the ACO?
It happened after, because it was in 2026 that training occurred, and the ACO was issued in 2025.
So you had not had RECRA training before you signed the ACO?
Correct.
Have you ever had experience working at a hazardous waste management facility?
Not within the hazardous waste management units specifically. I have been trained in many different laboratory settings as a hazardous waste generator and have had to comply with RIC regulations, labeling, and all of those details from the waste generator side in various chemical labs.
So your experience has been characterization and hazardous waste determination?
A part of that, yes, because that is a part of the labeling process to do it correctly. To do a hazardous waste assessment, you need to know what's going into it and make sure that it's reflected accurately on the label.
Prior to signing the ACO, had you received any formal training in RECRA enforcement?
No, I had not.
Have you since?
No, not other than the RICRA training in February.
Have you received any formal training on the process of conducting RECRA document reviews?
No, I have not had formal RICRA document review training.
Have you received any training specific to RECRA inspection?
I have not received RICRA inspection specific training. No.
Are you familiar with 40 CFR Part 264?
Vaguely, yes. I keep the reference books close by just because I don't remember all the regulatory frameworks. I work across 3 different regulatory frameworks currently.
Do you consider yourself a RECRA expert?
No, I do not consider myself an expert. I consider myself a RICRA student.
Do you have any training related to mining operations?
No, I do not.
Do you have any work experience relating to mine operations?
No,
Do you have any training or experiences related to mine hoisting equipment?
no,
Have you conducted any calculations or assessments of the materials at the WIP site?
no, I have not.
Have you conducted any independent verification of the condition of the hoisting equipment?
No, I have not.
And you've never been underground at the mine, WIP mine?
No, sir, I have not.
Have you been underground at any mine?
No, only underground at the caverns that are not far from the mine.
Have you ever had any interactions with the Mine Safety and Administration Health Administrator?
Not yet, but this job brings me new surprises every day.
But you are aware of MSHA's existence.
Yes, I'm aware of their existence.
And you're aware that MSHA has mining regulations that apply to the WIP.
I would imagine they would, yes.
And you're also aware that MSHA conducts regular inspections.
I would expect an analogous regulatory framework to RCRA for mining safety.
Due to your recent elevation to that position, you really had no, or you had very little input into the development of the enforcement action that's a subject to this matter, didn't you?
That would be an accurate assessment.
So you have not personally reviewed the procedures or protocols for operating the WIP.
No, I have not.
Do you know if the Hazardous Waste Bureau staff conducted any review of the procedures or protocols operating the WIP before presenting you with a summary of the GAO report and the NSFB letter?
As far as I am aware, no, they would not have necessarily reviewed protocols or operations before providing me the summary.
Are you aware of the staffing levels for SIMCO for operating the WIP?
No, I'm not.
Are you aware of the level of training required for personnel working at the WIP?
Not specifically. Based on the nature of the work and hazards, I would estimate they need approximately double training compared to workers at other sites.
Are you directly aware of inspections made of the hoist at the WIP?
I am aware of some inspections relating to the recent records review, but not specifically ones that I can recall related to the hoists.
Do you have personal knowledge about the processes and procedures of the WIP for routine maintenance of hoist systems?
No, I'm not aware.
Do you have personal knowledge about the processes and procedures at WIP for corrective actions on the hoist system?
No,
Do you know if anybody, the Hazardous Waste Bureau or the Compliance Enforcement Bureau, prepared or reviewed any information regarding the routine maintenance of hoist systems at the WIP?
none that I'm aware of.
How familiar do you consider yourself of the RCRA permit issued to WIP?
I have reviewed certain sections of the permit. I have not read through it end to end multiple times, which would be required to be intimately familiar with all sections. I'm only aware of the some of the broad categories.
So the permit is outside of the scope of the Compliance and Enforcement Bureau. Is that a correct statement?
The permit, the way that delegation is set up at NMED currently, would be enforced under the Compliance and Enforcement Bureau. The permit would be managed by the Hazardous Waste Bureau.
So to bring an enforcement action would, through the Compliance Enforcement Bureau now, would require the Compliance Enforcement Bureau to become familiar with whatever permit provision is being alleged to have been violated.
That's correct.
And would it be fair to say then that information should also be developed to show that there is an actual violation of that permit provision?
It would be fair that violations do require evidence, yes.
Do you know what subpart of Part 264 the WIP facility is regulated?
I don't recall exactly, but I believe it does fall under subpart X. I don't recall all the details, but again, I keep my reference book handy just to be able to refresh on these kinds of questions.
And you agree subpart X is entitled miscellaneous units?
That sounds correct from what I understand.
And do you know what that means?
It's a category that deals with wastes that are not defined in the other parts expressly, often because of a mixed nature.
Is it waste or waste management units?
The subpart X, I don't recall the phrasing exactly.
You agree that Part 264 has a specific subpart related to hazardous waste tanks,
That does sound familiar.
and it has a specific subpart specific to landfill.
Yes, there are specific portions speaking to landfills and those requirements.
And another subpart pertaining to container storage units.
Yes, that does sound familiar.
And a mine doesn't fit with any of those subparts.
Correct.
Do you know if subpart X contains any prescriptive requirements for the operations of a hazardous waste facility in a mine?
I don't recall offhand. I would need to review.
Do you recall if there are any prescriptive requirements for the operating of hoist in a subpart X facility?
I don't recall any portion of RCRA specifically dealing with hoists.
Do you have particular knowledge or personal knowledge about the names and number of hoists at the WIP?
I am aware of some of the information, but I couldn't draw you a diagram or tell you which hoist was where. I know that they have different purposes and that they are used differently. Some are meant for material transfer in and out of the mine. Some are meant for personnel, but that's the extent of my knowledge.
Are you familiar with the protocols that the WIP uses for egress of personnel?
No, I'm not.
Are you familiar with MSHA safety standards for escapeways at WIP?
I'm not aware. I believe that that is where the requirement is that they need to have at least 2 operating egress shafts or lifts, but I don't know for certain.
Do you know if it's a violation if you don't have 2 operating egress shafts if you're not operating?
If you're not operating, that often changes how the regulatory framework applies. Certainly it does for RCRA. I would imagine MSHA regulations are similar.
But you're not personally familiar with the MSHA regulation.
No, I'm going based on a standard of reasonableness.
Are you able to personally describe if any safety standards of MSHA have been violated by WIP?
As I'm not familiar with the specific standards, I would have to refer to them. But the only thing my bureau would be able to do would be refer any possible violations to MSHA.
Do you agree as the Bureau Chief that you are responsible for the information contained in an administrative compliance order?
Yes, I would agree.
And as the signatory to the ACO that's subject to this matter, you're responsible for the information in the ACO.
That's correct.
And yet you signed the ACO without signing the two documents that it's provided.
Correct.
So you're also responsible for the allegation that's a violation of the ACO.
Correct.
And yet you have no personal knowledge about whether the violations actually occurred or not.
That is accurate.
Did you read DOE's response to the DNSFB letter?
I am aware that there is a response. I have not read it.
Do you know if you or any of the staff responsible for preparing the summaries you relied on reviewed any maintenance records of the WIP before you signed the ACO?
I am not aware of any reviews of maintenance records before signing the ACO. I know that there were maintenance records reviews unrelated to the hoists sometime after during that records review I've referenced.
But you are aware that those maintenance records, including operators logs for the hoist, are available and are presented to the NMED per document request.
Yes, I am aware of that.
Do you know if anyone who prepared the summaries for your review that you relied on, or you reviewed any engineering assessments from DOE or SIMCO before signing the ACO?
No.
Did you or any of the staff who prepared the summaries take any confirmatory steps to verify the information in the GAO report or the DNFSB?
No, we took those, both the GAO report and the DNFSB letter to be self-authoritative.
For record violations?
Authoritative to give us reason to be concerned regarding the contents of those letters. So this was primarily about violations of a permit condition rather than other RCRA standards, because the contents of the ACO are not primarily focused on hazardous waste.
Is the NMED attempting to regulate the WIP beyond the authorization provided under RCRA?
No, NMED, as far as I'm aware, has no reason to be seeking additional regulatory authority over WIP.
So you said that the GAO report and the DNSFB letter are, I think you said self-authenticating. I may be
I believe I said self-evident, but
self-evident. And I asked of RCRA violations. So I guess I'm asking that again. Do you believe that that report and that letter are evidence of violations of the hazardous waste permit?
that would be the contention of the ACO and the stance of NMED. That is where the concern is of the permit conditions, specifically relating to the systems and facilities and the auxiliary systems and facilities being maintained in a good status of repair toward the end goal of safety of human health.
Did you or anyone else at the NMED make any effort to analyze the purpose for the GAO report?
I'm not aware of any such effort.
Did you or anybody from NMED make any effort to understand the definitions utilized in the report?
The definitions that I was concerned with, I would consider to be commonly understood definitions regarding the status of infrastructure and mission critical infrastructure. I didn't believe those were needing further clarification.
I guess we're talking about the words substandard and inadequate.
Those I don't know that we discussed in detail, but yes, it is important to agree on a definition of those terms.
And there very well may be definitions for those terms that you didn't find.
That's plausible. I don't remember reading them specifically.
Do you know if anybody from the GAO or the DNFSB actually conducted any inspections of the infrastructure at the WIP?
I am not aware of any actions taken by either entity in regards to the report or the letter.
Were there any inspections conducted by your team or the Hazardous Waste Bureau after receiving the GAO report or the letter?
Not that I'm aware of, no.
Did you make any inquiry of the people providing you the information as to whether there had been any effort to verify the concern about compliance with the permit?
No, I don't believe I asked them to do any further clarification.
Do you know if anybody took any efforts to verify the information and to verify that actual violations of the permit had occurred?
No, I'm not aware of any firsthand actions.
So am I to understand then that relying solely on the summaries of the GAO report and the DNFSB letter, you issued the ACO alleging that violations of the record permit occurred?
Yes, that is correct.
Did NMED request any records or information from DOE or SIMCO regarding the hoist before issuing the ACO?
Not that I'm aware of.
Did you or the NMED, anybody at the NMED, contact DOE or SIMCO to discuss the alleged violations before issuing the ACO?
Again, not that I'm aware of. There may have been conversations before my tenure in this position. I'm not certain.
Do you know if there was any outside expert retained to evaluate conditions of infrastructure WIP before signing the ACO?
I apologize. Can you repeat the question?
Was an outside expert retained to evaluate the conditions of infrastructure at the WIP before signing the ACO?
No, not that I'm aware of.
To your knowledge, have any of the record inspections conducted by NMED ever identified concerns regarding infrastructure at the WIP?
Only that they have come back, again, hearsay, that they have come back hearing that there was need for a number of infrastructure upgrades. I believe that conversation involved the air shaft project that was in process at the time from a prior year inspection. But that inspection happened, I believe, before my time, and I'm not sure of the exact contents of that report.
You agree, though, that there are no inspection findings from the NMED that support the alleged violations in the ACO?
That would be an accurate statement as far as I'm aware.
So you became aware of the GAO report in your first month of the new position at the Bureau. Who briefed you on the GAO?
The GAO report, I was briefed in, I believe it was a meeting with Megan McLean and Bruce Basil. I believe that was when I first became aware of it.
Now, did they tell you that they expected there had been violations of the record permit based on those reports?
I believe that was being drafted into the ACO at that time. The majority of what I recall from that conversation was focused around the concerns for worker safety based on the contents of the report.
Who determined that violations occurred at the WIP that led to the issuance of A?
That was a determination, I believe, ultimately by Bruce Basil.
Do you know if Mr. Basil had any other information available that proved violations of the permit other than the GAO report or the DNFSB letter?
Not that I'm aware of.
How long did it take approximately from the learning of the report in the letter and the concerns to the issuance of the ACO?
From my perspective, I believe it was approximately 2 weeks. So this is one of a handful of enforcement actions that had been initiated prior by the Hazardous Waste Bureau that I was coming into the middle of, so to speak.
So did I hear you right that one of the factors for not seeking penalties was got better notes. There were no immediate hazards.
There were no immediate hazards to human health based on the information we saw. It was more a long-term ongoing infrastructure question.
And is it normal to go from initiation of an enforcement action to issuance of an ACO in 2 weeks?
I suppose it depends on a variety of factors. Sometimes that may be a normal timeline, and sometimes that may not be. In this instance, the process had already been ongoing, I believe, approximately 2 weeks prior, possibly longer, I don't know, to when it came to my desk. And from there, it was approximately 2 weeks.
So I recognize that sometimes things have to move faster, but isn't one of the factors usually if something's a imminent hazard to human health or the environment?
Yes, typically that is a consideration.
And you said that you did not view this as a imminent hazard.
That's correct.
Then what was the rush?
The rush was, I think, largely due to the factor that leadership had been available to review. It had already gone through the review processes and it was ready for issuance. And that was part of my initial tasks in that first month was to proceed with this ACO issuance.
Didn't you tell me in the deposition that the goal in the Compliance Enforcement Bureau is to work with the regulated entities and try to encourage compliance?
Yes, that's correct.
Then why was that not happening in this matter?
That's a valid question. I'm not certain what exactly precipitated the timeline, other than I think, like I said, availability of schedules. So I don't know that it was intended to be what could seem as accelerated. I think it was a normal process that happened to have an early availability window for schedules. That's what I believe to be the case.
So you agree it would have been reasonable to have reached out to the permittees and asked them if they had any information about the current condition of the hoist?
That probably was why the original idea was to have it written up as an NOV. I can't speak to that specifically. And there was a decision made above my level regarding that status, and it was reformed into an ACO.
Do you have any information that you can share with us as to what prompted management to want to move this so fast?
I am not aware. There may be considerations that I'm simply not privy to.
Do you know if management had any information other than the GAO report or DNFSB letter that there were violations occurring at the WIP?
Not that I'm aware of.
You read a provision from the Hazardous Waste Act earlier about issuing ACOs, and you agree that one of the requirements to issue an ACO is a determination that a violation has happened, is happening, or will happen.
Yes, that's correct.
And in this instance, has the secretary determined that a violation has happened?
That would usually be the case before an ACO is issued or it's decided by one of the delegates of authority, depending on the nature of the particular facility.
And so Mr. Basil was the delegate under this situation.
Correct.
And the ACO is written stating that that violations have happened.
Yes, I believe that's correct. I don't have it open, but I believe that's correct.
When you were presented with the ACO, you did not draft the ACO.
That is correct.
And when you were presented the ACO for your signature, did you make any edits?
Not that I recall, no.
Did you ask any questions about verifying information of the violations?
No, I did not.
How long before you were presented with the ACO to the time you signed it?
I believe I was presented a draft somewhere in mid to late July. I can't recall the exact date of 2025. And I reviewed the final draft before signing. That was, that may have been approximately business week. So it may have been 4 or 5 days, something like that.
Have you issued any ACOs since this one?
Several, yes. I don't recall the exact count, but I have issued several.
This was your first.
I don't recall if this was my first. It may have been the second one that ended up issued. It was one of the first. It was one of the first of the cases that were transfers from HWB that I saw. Can't recall if it was first or second. It was in the first few, definitely.
Is your program area, the Compliance and Enforcement Bureau, operating with such speed for other ACOs?
We have issued, I believe, something more than 700 enforcement documents. The actual number might be closer to 1,000, including notices of deficiency, since starting in 2025. So we have been working to undo the backlog for the time when enforcement was deprioritized.
How large was the backlog?
In total, many thousands of violations across multiple entities under multiple regulatory frameworks.
And how long had those enforcement actions been pending?
Some of them had been pending for approximately 3 to 7 years, somewhere in that time frame. Most of them within the last 3 to 5.
Did any of those enforcement actions involve facilities with releases to the environment?
There were, yes.
And do you consider those high priority enforcement actions?
Yes, I would.
And have any of those been processed in a month to 6 weeks?
Many of them have been drafted within that time frame, but because of various availabilities or schedules may have had delays that the ACO in this hearing was not subject to.
Who provided you the ACO in its final form for your signature?
I believe that came back from OGC. I don't recall. It came through one of the many emails. I get a rather large volume of emails, so I can't recall exactly who the sender was.
Do you recall who directed you to sign the ACO?
That was following a discussion with Bruce that it was ready for issuance.
Bruce Basil.
Correct.
Did you receive any explanation as to why why the matter was elevated from an NOV to an ACO?
No, I don't believe so. I had heard something similar to what I believe was discussed earlier, that there was a prioritization of ACOs, but that's the extent of the information I can provide there.
Going back to your meeting with Ms. McLean and Bruce Basil to discuss the ACO, do you recall if there were any other participants?
I imagine there were, but I cannot recall any others offhand.
Was there any discussion during that meeting about one particular hoist versus another?
No, there was not.
Did you bring up the incident that you had found from your Google search?
I did, and only to suggest that it seemed this was a matter to take seriously.
Do you have any indication, or anybody from NMED have any indication that Simcoe or DOE have taken this matter anything less than seriously?
No, not at this time.
Was there any particular discussion in that meeting about the actual condition of any hoist?
Not that I recall.
Was there any discussion between you and Ms. McLean and Mr. Basil about this matter potentially going to hearing?
No, I don't recall that coming up.
Were you on the email chain that discussed that there was a low probability of this matter going to hearing because there were no penalties being sought?
I may have been. I can't recall off the top of my head. That topic sounds familiar, but I can't recall for certain if I was on that email chain or not.
I don't know how to turn it off. I should have known one.
Oh, sorry.
I'm sorry.
I was sorry, Mr. Woodward. I was just going to see if you and Madam Hearing Sir would be amenable to a break.
Sure.
Alrighty, let's take 15 minutes. I'm back at 2:45.
Thank you. Turn it off.
Mr. Woodward.
Thank you. Dr. Staggs, were you involved in the decision to overrule the Hazardous Waste Bureau's recommendation to issue an NOV?
No, I was not.
Do you have any knowledge as to why the decision was made to issue an ACO instead of an NOV?
I do not have an explanation, no.
Do you agree that when it becomes final, an ACO is an enforceable legal document,
Yes, I agree.
same as a permit?
I would agree they are similarly enforceable legal documents.
And any violation of an ACO is subject to further enforcement.
That is correct.
And enforcement of an ACO can lead to civil penalty.
Yes, it can.
As the director of the Bureau or Compliance and Enforcement Bureau, do you agree that a compliance history for a regulated entity is important?
Yes, I would agree that the history is important. The compliance history is considered whenever we are issuing an ACO, especially one with penalties. And as a point of clarification, I think it's important to note that the history of non-compliance is considered as repeat of the same types of violations rather than generally there were violations in the past, therefore such and such a value for history of non-compliance. So there is some weighing and degree of reasonableness that I would say is applied to that standard.
And do you agree also that future permitting decisions can be impacted by a an applicant's compliance history?
I would say yes, it would be a consideration. I don't know how much weight that would have in that conversation. I can't speak to that piece of it, but I haven't been part of any permit change discussions related to compliance history, so I don't know how those would proceed.
But you would agree that an ACO carries the full force and effect of a law,
Yes, I would agree.
and that anybody who receives an ACO should take it very seriously.
I would agree.
Do you agree that enforcement action can impact a significant right of an individual or a company?
The impact could be significant, yes.
When how long has the compliance first philosophy been part of the NMED?
As far as I'm aware, that has become a focus since the implementation of the Compliance and Enforcement Division. That, depending on where you start the time clock, may stretch back as far as about 5 years. The intent, as I understand it, was to be more EPA-like in the division between permitting actions and compliance and enforcement to help simplify some of the conversations so that there wasn't complex negotiations for every single permit revision. That was what I understand is the intent.
Would you agree that compliance first means working with the regulated community, emphasizing education, and understanding of why someone is potentially in violation before issuing an enforcement action?
I would agree, yes.
And do you agree with that philosophy?
Yes, and I have implemented that philosophy in other ACOs and settlement agreements as a result of those.
Do you agree it's critical to evaluate facilities with equal weights and measures?
Yes, I do.
And you also agree that it's important to treat federal facilities the same as you would privately owned facilities?
Yes, that's correct.
And yet, no one from NMED contacted DOE or Simcoe prior to issuing this ACO. Why did that happen?
That I'm not aware of. The issuance of the ACO was my, I believe, first contact with any of the folks at WIP.
Did you inquire as to why the compliance first philosophy was not being utilized in this matter?
In this matter, I was not sure I had the entire history of interactions between NMED and WIP, and so it would be unreasonable to make any kind of assumptions one way or another a couple weeks into a new bureau under a new division with existing relationships and existing enforcement documents from my perspective coming to my attention. There was not objectively reason to question the train of decisions that had led us to the ACO.
So you didn't question?
No, I did not.
So you agree that in this matter, there was no opportunity given to Simcoe or DOE to address the concerns that were raised by the GAO report or the NFSP?
Not that I'm aware of, no.
provided an example in your deposition involving New Mexico Highlands University. You recall that?
Yes, I do.
And you described the normal process would be inspection, exit conference, and then ACO.
Often, yes, unless it comes from some other source of information. The initiation of the New Mexico Highlands University inspection was from third-party input for I believe it was a public complaint that came in from a whistleblower on that case.
And did the agency take necessary steps to verify the information received from the whistleblower?
We did an inspection following that, yes, and the site was not in great shape, and the hazards to workers and students there was quite high, and the building had to be shut down.
Was the university given any opportunity to respond before the issuance of an ACO?
In that case, I'm not aware that they were given any opportunity.
But there were risk. You said high risk of hazard to students and
Yes,
faculty.
there was.
Do you have access to a copy of the ACO?
I believe so.
Do you have enough?
Yes, I have it right here.
I believe in your words, the violation number one was failure to maintain infrastructure in good repair.
Yes,
What permit section is alleged to have been violated by this allegation?
that would be section 1.7.7.
Do you agree that the purpose of the hazardous waste permit is to assure protection of human health and the environment?
Yes, I agree.
And what part of 1.7.7 did Simcoe and DOE allegedly violate?
The portion of maintaining facilities and systems, as well as the auxiliary systems and facilities in a state of good repair. That's the allegation here.
Do you have I'm going to hand you what's been marked as Respondents Exhibit 3. Does this appear to be a accurate copy of that permit section?
Yes, I believe it does.
So do you agree that this requirement to properly operate and maintain all facilities is to achieve compliance with the conditions of this permit? And I ask you to read the first sentence of the permit section.
Under 1.7.7,
First sentence.
the permittees shall at all times properly operate and maintain all facilities and systems of treatment and control and related appurtenances, I believe, which are installed and used by the permittee to achieve compliance with the conditions of this permit.
So you agree that the requirement is to maintain good repair to achieve compliance with the conditions of this permit?
I believe that is an accurate reading.
Can you tell me what conditions of this permit have been violated?
The hoists for the treatment and control, that would include the proper transition to the final resting place of the drum as part of the operations of this permit, and that I believe would include the hoists.
But that's not the question I'm asking. The question I'm asking is, we agree that we have to maintain facilities in good condition to achieve compliance with conditions of this permit. So which permit condition has been violated? What can you point me to another place in the permit that the Simcoe and DOE have failed to comply with as a result of the alleged failure to maintain the facilities in good repair?
No, I cannot point to another permit section.
So you agree this is a performance-based requirement?
I suppose you could characterize it that way, yes.
So you're not alleging that Simcoe or DOE failed to properly inspect the facility?
No,
You're not alleging that DOE or Simcoe failed to properly engage in corrective action for any issues found from an inspection?
correct.
And you're not alleging that Simcoe or DOE failed to engage in normal routine maintenance of the hoist system?
The maintenance of the hoist systems is the only thing that is in question based on the contents of the GAO report and the DNFSB letter.
Do we know how GAO or DNFSB defines maintenance?
I don't believe that I recall their definition, no.
Is it possible that they're talking about long-term replacement and upgrades rather than routine maintenance to ensure safe operation?
I suppose that's possible. To confirm, I would need to review their definition.
But you don't know.
Not offhand, no.
And you're alleging that Simcoe and DOE have failed to properly maintain their facilities to continue operating in a safe function.
Yes, that is the contents of the allegation.
Do you have any information to show that these hoists have ever been operated in an unsafe condition?
No direct evidence, no.
Do you have any personal knowledge that DOE or SEMCO intentionally ignored a maintenance issue and operated the hoist in an unsafe condition?
No, no direct evidence of that.
Do you agree it's quite possible that every time an issue is identified, that a hoist is taken out of service and fixed before putting back into service?
It's entirely plausible, yes.
And is it entirely plausible that they conduct verification inspections to confirm that any issues have been corrected prior to putting a hoist back into condition?
I would expect verification inspections, yes.
And if you had received information confirming all that, would you still allege that there was a violation of failure to properly maintain the facilities to achieve compliance with these permit conditions?
No, I would not continue to allege that, but I have not been provided such information at this time.
And you never asked for that information?
Not to my knowledge, yes.
And DOE or SEMCO didn't know you wanted the information until they received the ACO alleging a violation.
That seems consistent with the timeline, I understand, yes.
Let's go back to the ACO and look at violation number 2. Do you know exactly what evacuation equipment is being referred to in this allegation?
I couldn't tell you which specific hoists are being referred to in this allegation, no.
So your understanding of the condition of the hoist comes completely from the DNF-SB letter.
That's correct.
And you've received information that that letter was written not as a compliance inspection, but as an effort to acquire funding for the facility.
Yes, that is what has been presented as part of this hearing.
And that you presented that information as part of this hearing.
Yes.
And what permit provision is being alleged to have violated by the alleged degraded condition of the escapeway hoist?
This is referring to permit part 2, section 2.10.1. And the specified portion of the contingency plan, which is permit attachment D.
So escapeway hoists are not listed as required equipment in 2.10.1, right?
I don't recall offhand. I would need to review part 2 again.
Okay. Prior to signing the ACO, did you review any of the permit conditions that were alleged to have been violated?
I did.
Did you review this provision?
I did review this provision, and I reviewed it again when we were looking at the records review pertaining to the internal communication system that was down for a period of time.
Are there any allegations in this ACO about the internal communications?
No, I believe this was focused expressly on the escape ways and those particular hoists.
And how are the escapeway hoist brought into this alleged violation?
Simply that they were part of what the DNFSB letter cited as one of the issues that was identified.
But the escapeway hoists are not listed as required equipment in this permit provision, are they?
Not in the section provided, no.
Are you familiar with the regulatory requirements of MSHA for maintaining escapeway hoist?
I'm not familiar in detail. The only piece of that I've gathered as part of this broader proceeding was that there are 2 required hoists at any given time.
And that's just the limit of your knowledge about the escapeway hoist requirements?
As far as I have studied the topic thus far.
Are you aware of the processes and procedures implemented at the WIP for escapeway,
No.
or getting people from the underground?
No, I'm not familiar with those protocols.
So you've not reviewed any of the protocols for getting people from the underground?
Correct.
And you've not looked at the maintenance or repair logs or inspection logs or anything pertaining to any of the hoists, or including what would be labeled as the escapeway?
Correct. Not that I recall.
And you don't know which hoist is specifically being referenced in this ACO violation number 2?
Not offhand, no.
Is there a difference between a degraded condition and an inoperable condition?
Yes, I would agree.
And I think you and I talked about this before in the deposition. Is it possible to operate old equipment safely?
I would say so. As an owner of a car with approximately 300,000 miles, it is possible, but it requires a lot of elbow grease and a large volume of new parts.
So now we're talking about reliability versus safety.
They are often related because you need to be able to rely on key systems that are related to safety. And if you haven't addressed those, you've probably overlooked something important.
Do you have any information to share that proves that the WIP has in any way operated this facility in an unsafe condition?
No, no objective proof outside of the GAO report and the DNFSB letter contents.
Did the GAO report or DNFSB have any information that there has been a failure to able for the facility to be properly evacuated?
Not that I recall, no.
Let's look at violation number 3. You agree that the WIP conducts routine inspections of its facilities.
Yes, that is correct.
Do you have knowledge of how often the WIP inspects the hoist facilities?
No, not offhand.
Let's look at table E-1. This has been admitted as Respondent's Exhibit 2. Does this look like an accurate reproduction of the table from the WIP hazardous waste permit?
This does, yes, this looks familiar.
And does this table specify a requirement for inspection frequency?
Yes, this does.
And if we were to look at first item listed in the table, is that one of the hoists that are subject to the ACO?
That is one of the hoists, yes.
And it's the air intake shaft hoist, correct?
Correct.
Then we sometimes referred to as the AIS hoist. And what's the inspection frequency required for that hoist?
Pre-operational.
And there's a footnote by pre-operational, right?
Correct.
So if we want to know what that means, we have to go look at the footnote.
Yes, that is an accurate statement.
And so what does pre-operational signify?
Pre-operational signifies that the inspections are required prior to the first use during a calendar day. For calendar days in which equipment is not in use, no inspections are required. For an area, this includes area is clean and free of obstructions for emergency equipment, adequate aisle space, emergency and communications equipment is readily available, properly located and signposted, visible and operational. For equipment, this includes checking fluid levels, pressures, valve and switch positions, battery charge levels, pressures, general cleanliness, and that all functional components and emergency equipment is present and operational.
So that's prior to every day before use, you have to inspect the air intake shaft.
Yes, that would be correct.
And then if we switch over to page 13 on table E-1, and the third item down, what item is that?
The salt handling shaft hoist.
And so that would be another hoist that is the subject of this ACO.
Yes, that's correct.
And what's the inspection frequency for that hoist?
Pre-operational, which would be the same requirement we just reviewed.
And if we flip to the next page, 14, and 1, 2, 3, 4 items down, which item is that?
The waste hoist.
And that's also one of the hoists that's the subject of this administrative compliance order.
That would be correct.
And what is the inspection frequency for that hoist?
Pre-operational.
This table also contains a procedure number and inspection criteria for each one of those hoists, correct?
That's correct.
And so they're required to implement this procedure every day these hoists are used.
Yes, that would be correct.
Do you have any information that Simcoe or DOE has failed to conduct these inspections as required by this permit?
No direct evidence of that, no.
And the criteria that they're required to look at are also defined in the footnotes, aren't they?
Yes, they are.
They're required to look for deterioration.
Yes, that's correct.
And that's footnote B.
Yes.
And it defines deterioration to include obvious visible cracks, erosion, salt buildup, damage, corrosion, loose or missing parts, malfunction, or structural deterioration.
Yes, that's correct.
And operators of the facility are required to look for that information on these hoists every day they're in use.
Yes, that would be correct.
And do you know whether these procedures require there be follow-up if any of these criteria are identified as an issue or a problem?
I would imagine they would require follow-up, yes.
And are you knowledgeable that logs are required to be kept of every inspection that's required of these hoists?
I would imagine that's part of the regulation, yes.
And there's a requirement to conduct any corrective action prior to putting a hoist into operation?
That would be a reasonable requirement.
And would it be reasonable to assume that those requirements are consistent with MSHA requirements that are referenced in the inspection criteria?
Based on what I read here, yes.
Did the GAO report or the DNFSB letter mention anything about the procedures and protocols implemented to ensure safe operation in the underground at the WIP?
No, not that I recall.
Did you think to make any inquiry as to whether operations were being implemented in accordance with the NMED record permit to assure safe operations at the facility?
No, I did not make any additional inquiry.
So let's look at violation number 3, or did we already? Did you tell me what violation 3 is?
Yes, that was identifying equipment deficiencies. Uh, no, I don't believe we've covered violation 3
Okay.
expressly.
What is violation 3?
Failure to address identified equipment deficiencies under permit. Oh, no, we did just cover this one. This was the section E1. So I believe we are now in violation 4, unless you want to review 3 again.
Well, what I'd like to know is, this one is that there was failure to conduct specific corrective actions because after issues were identified.
For violation
For
4,
violation 3.
for violation 3. Yes, this was looking at failure to correct after issues had been identified. Yes, that is what it states.
What specific issues did Simcoe or DOE ever fail to correct?
The contents of the report were pointing to the degraded state of equipment largely because of age rather than the maintenance stats.
But I think you previously agreed with me that age is not a violation,
Correct.
and that old equipment can be operated safely.
Yes, that's correct.
May require more elbow grease, may require a little more attention, like your old car. But every now and then you put new tires on it, make sure the windshield wipers are replaced, and that car can still be operated safely.
Yes, that's correct.
Do you have any geotechnical training?
I do not.
Can you provide us any proof that the hoist no longer meet the design basis?
No, I do not have proof of that. The question came up as a result of the contents of the GAO report and the DNFSB letter.
I think I heard it referred to as concerns. As a matter of fact, I think the ACO says concerns.
I believe that word is in there. I don't recall how many times it's used, but yes.
But in looking at the ACO, it actually states that it's a violation.
Yes, it is stated as a violation.
In your mind, is a concern a violation?
It may be if there has not been a study done. The challenge with this particular violation is there hasn't been any additional information provided since then to review whether or not this has been evaluated.
What evidence do you have that permittees have failed to continue maintain the integrity of these hoists?
The part of the question comes from the nature of the DNFSB letter pointing to the state of degradation specifically in the hoists. The general reason for concern there is the nature of these mine shafts having been salt walls. That salt is not static as another mine shaft might be static. They're not one and the same. The chemistry involved means that necessarily those walls move and shift and change dimensions. That creates opportunity for distortion of the mechanical structure of the hoists. And that's where the concern comes from. And some readings that I did, I believe, also involved the one particular hoist, and I can't remember which one it was, that was highly impacted. It may have been the salt hoist shaft that was impacted by a much larger salt drift than was expected. So there are some questions that come up as a result of that the DNFSB letter points to. And at the end of the day, we are looking to make sure that the hoists are safely operable. So it's good to see the specific inspection criteria outlined in the table for each of the hoists.
Did you look at these inspection criteria before signing the ACO?
No, I did not.
So that was a good long answer, but again, what proof do you have that the hoist no longer meet the design basis?
I don't have objective proof.
Where in the permit is it required that a permittee provide requalification?
I have not read a requalification stipulation in the permit.
Do you know of any requalification requirement in the record regulations?
Not that I'm aware of.
What is FIMS?
The Federal Infrastructure Management System.
Is FIMS required under the record permit?
Not as far as I'm aware, no.
Does any of the FIMS information get reported to NMED under the record permit?
Not that I'm aware of.
Do you know if the FIMS data has anything to do with the hazardous waste management?
Offhand, no, since I have not reviewed the FIMS information.
And yet, in the ACO, you claim that permittees have failed to ensure accurate documentation of infrastructure conditions in violation of section 1.7.7 of the permit.
Yes, that is the allegation.
What condition of the permit have permittees violated as a result of the possible inaccurate documentation in FIMS?
It calls into question the reliability of some reported data. If there are inaccurate information being entered into the FIMS system, whether or not that was done intentionally is not part of our concern, but the question about is the data coming from WIP reliable, or does that suggest that perhaps there are some shortcuts being taken?
Do you know what data was alleged to have been inaccurately placed into the FIMS?
No, I don't know exactly what data.
Do you have any evidence or any information that the WIP has provided inaccurate data to the NMED?
No, I do not.
So there's concern but no proof?
That would be accurate.
NMED doesn't have access to data in the FIMS, does it?
Not that I'm aware of.
Is FIMS required by the New Mexico Hazardous Waste Act?
No, I do not believe so.
Is FIMS required by the New Mexico Hazardous Waste Management Regulations?
Not that I'm aware of.
You stated in your deposition that you thought treating the FIMS data accuracy as a permit violation is a peripheral application of section 1.7.7. Do you still agree with that?
Yes, I would still agree with that assessment.
Do you know if when NMED conducts a recurrent inspection of the WIP facility, do they look at FIMS data?
Not that I'm aware of.
That's all the questions I have.
Thank you, Mr. Woodward. Mr. Hall, do you have questions?
I don't know. This one.
Thank you. Ms. Weatherly, do you have redirect?
None.
All right, thank you. Oh, yes, Mr. Woodward.
I just wonder if we could take a 5-minute break.
Absolutely. Let's take 6 minutes and come back at 3:40. Thank you. Thank you. Let's come back from the break. Mr. Woodward.
Is that the close of the
Department's presentation? I believe it is. Yes.
At this time, I'd like to re-urge our motion to dismiss.
All righty. I can't do that, but your motion is noted.
Okay.
And it's not granted.
I feel like the testimony in today's hearing has verified the information that was presented in our motion dismiss and the summary judgment, and would like to re-urge that at this.
And I understand why you're doing that. And I took your arguments earlier at face value. So thank you for that. But I'd like to hear from your witnesses.
Okay. I want the record to reflect that we're re-urging our original motion dismiss. We're also making a motion to dismiss under the Rules of Civil Procedure of 1-041B. And we're making reference to the Rules of Civil Procedure from the regulations of the NMED that talk about where there is not a specific procedural rule on place that the hearing officer may refer to the Rules of Civil Procedure. And that rule from the NMED is 20.1.5.100. And at this point, now that the department has rested their case, we feel like that they, with the burden of proof, they have not met this, and therefore we're making that motion.
All right, thank you for that. The motion is denied so far as I am concerned. Obviously, the ultimate decision will be made by Deputy Secretary Roderick. And in the meantime, I'd like to hear from your witnesses.
Thank you. Respondents are going to call Michael Jones to us. Is it okay for the hearing officer if I stay here instead of moving down next to you?
Absolutely. Mr. Jones, would you spell your first and last name, please?
Michael Jones, MICHAELJONES.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Woodward. Oh, I'm sorry, Mr. Woodward, I forgot to invite you to do an opening statement if you wanted. Totally forgot.
Thank you. I'm getting
movement from one to the next. I am going to do a short opening statement. Sorry, I got too much paper here. Thank you, Madam Hearing Officer, Counsel for the Bureau. WIP is one of the most heavily regulated, inspected, and reviewed hazardous waste facilities in New Mexico, if not in the nation. We are faced with a 5-count administrative compliance order with no NMED site visit, no record review, no expert review of the facilities, no independent findings. The entire case rests on 2 documents from 2 federal agencies that do not even regulate WIP. Those documents are hearsay, and they are no evidence of any violation of these permits. WIP is a program, deep geologic repository for disposal of U.S. defense-related transuranic waste. It's the only one in the nation, and so it gets a lot of attention. It's a federal facility owned by the DOE and operated by SEMCO. It's authorized by federal act, the Land Withdrawal Act, that mandates the mission for the WIP, that 6.72 million cubic feet of transuranic waste being placed in this facility. And that is what Department of Energy and SEMCO are charged with doing, safely operating this facility to accomplish that mission. The state of New Mexico has oversight over this facility through the Resource Conservation and Recovery Act, and is implemented through the state through the Hazardous Waste Act. It is a hazardous waste management program. They have no oversight of the nuclear portion of the facility, and it is limited to those authorities granted pursuant to the Resource Conservation and Recovery Act. The WIP is a Subpart X miscellaneous unit. That means that it's an undefined unit under the hazardous waste regulations. It is commonly referred to, Subpart X is commonly referred to as performance-based regulations. And this facility has been identified and has been designed, modeled, constructed, and operated to meet those performance standards with the ultimate goal of protection of human health and the environment. And there are many permit conditions. You heard us talk earlier about the size of this permit. It's notebookfuls. You can't transfer this permit with a single email. You have to go in and look at it on the web page. It covers all aspects of the facility. And it's very hard to understand how a regulatory authority can essentially ignore their responsibilities through inspection and confirmation of that inspection and rely on hearsay documents to allege violations of the permit. What you heard in their portion of the case was concerns. They had concerns, they had questions, they wanted information. But what they didn't do is pick up the phone and call WIP. They didn't ask for any information about how the facilities are confirmed to still be safe. They didn't ask about the operations. They didn't ask about the inspections or the corrective actions or the maintenance program, all within the purview of the NMED. All information that you're going to find in the testimony provided to you today and tomorrow has been provided to the NMED.
Much of this information is in their possession, but they didn't take a look as to whether there was information to confirm or validate the concerns that the GAO and the NFSB letters report. It's important to understand the layered federal oversight of this facility. It starts with the Department of Energy. As the owner of the facility and going all the way back to the original Atomic Energy Act, Department of Energy is a self-regulated facility. They are required to make sure that all of the directives that they, being the WIP, meet all the directives of the Department of Energy, and they're numerous, all with the importance of maintaining a safe environment that's protective of human health and the environment. Then you have the EPA, and the EPA looks at not just the radioactive portion, but they also have oversight of the hazardous waste portion, which they have delegated to the NMED, state of New Mexico. But EPA also looks at the radiological safety of the facility. They look at and confirm that the facility is going to meet the long-term performance standards. And when I talk about long-term, we're talking about long-term, tens of thousands, if not hundreds of thousands of years, that this facility will be in a safe environment and not a threat to our ecosystem. And then you have the Mining Safety and Health Administration. It's another federal regulatory oversight. And they are the regulatory oversight that has the expertise in mining safety. And a lot of these issues that have been raised in this ACO all come back to mining safety, all come back to whether the hoist, both the hoist for taking waste to the underground, the hoist for bringing people up, taking people down, and maintaining so that there can be a proper evacuation of people in case of an emergency. You're going to hear a testimony that MSHA, which is the acronym for this agency, they investigate this facility quarterly, and they do extensive inspections of these hoists. And they have not once found these hoists to be in an unsafe condition. We can't run from the fact that the hoists are aging. And we can't run from the fact that they require extensive maintenance and elbow grease, as you heard earlier. But that doesn't mean they're unsafe. And that doesn't mean that they're being operated in violation of the permits. And the permit, we've heard, agreement is there, again, for the protection of human health and the environment. And it's important to remember that all of the things required by the permit are to achieve that goal of protection. And so all of those items have to be strictly complied with. We did not hear one bit of information about the WIP taking any shortcuts on any of the requirements under that permit. There's no shortcuts on training. There's no shortcuts on inspection. There's no shortcuts on correcting any items found in the inspection. There's no shortcuts on the maintenance of the facilities. I think one of the problems we run into is trying to apply regulatory terms from RECRA and the NMED to what GAO or DNFSB says. They're talking about deferred maintenance. They're talking about major capital projects. They're talking about replacement and upgrades, but they're not talking about the day-to-day maintenance that assures that these facilities are safe. They didn't even look at that. And unfortunately, neither did the NMED. They just went post haste in about 2 weeks and issued an ACO. I kind of feel sorry for Dr. Staggs. He shows up, and the day he shows up, they put an ACO in front of him and says, here, sign this. And didn't give him any supporting background on it. Didn't even give him a chance to read the documents that the ACO is based on. NMED has a burden of proof. I don't think there's any doubt. When you're bringing enforcement action and you're alleging violations of a permit, you have the burden of proof to bring the evidence that those violations occurred. The GAO report and the DNFSB are not proof of violation of these permits. Now, the claim that somehow that this ACO is not important or is not significant and doesn't impact the rights of the permittees, I think is an insult to the whole compliance program. Compliance is important. And you're going to hear from these witnesses from the WIP. It's safety first and it's compliance. The mission is ultimately to safely dispose of all that volume of waste, but their first mission is safety. I've heard it said several times in meeting with these people now, and I'm so impressed by their professionalism, but they say over and over again, we do not operate in unsafe conditions. And it is hard for them to have a regulator tell them that they're operating in non-compliance with their permits. If a hoist has an issue identified, and you heard that they're inspected every day, and they're inspected with great detail as to whether they're operating properly and whether they're still in a good, stable condition for operation. If any issue is identified, they're taken out of service. And they are not put back into service until that condition is repaired. And there's nothing in the permit that talks about taking a hoist out of service being a violation of the permit. What's a violation of the permit would be to put that hoist back into operation without fixing any of the conditions. And that just doesn't happen at this facility. It's too overly regulated. There's too many eyes on it, and it's too important. And they take this very seriously. We have three witnesses. Michael Jones is going to discuss the regulatory framework. He's the advisory environmental compliance specialist. He's responsible for interfacing with the NMED to make sure the NMED receives all the information required under the permit. He's going to describe the training regimen. He's going to describe the inspection regimen. He's going to describe the monitoring of making sure that all inspections are conducted per schedule and all inspection logs are recorded on schedule and are complete, and that they also make sure that all corrective actions are taken for any issues identified during the inspection. And then they record all of that information again, and they monitor that and confirm that all corrective actions are taken. He's going to also show that all that information was provided to NMED. It's been provided on an annual basis. Every time NMED conducts an inspection of this facility, the operator's logs are packaged up and provided to the NMED, showing that the inspections are not just occurring on an everyday basis, they occur on every shift. They're doing more inspections of these hoists than what the permit requires. Our next witness is Lincoln Griswold. He's the technical services manager. He went to work he's from Carlsbad, and he went to work after he got his degrees at the WIP as a hoist operator back in 1992, I think it was. And he's going to provide the explanation of safety versus reliability. He's going to explain that the GAO report and the DNFSB letter are reliability issues. They're those issues about driving the old car and having to replace parts more often and having to work on it a little extra harder to keep it operating, to maybe not get the throughput that would be ideal that you would strive for. But he's also going to talk about the importance of never operating these hoists in an unsafe condition. And he's going to talk about the procedures and the processes in place and the inspections that occur that assure that these hoists are operated in an unsafe condition. And if they're not in a safe condition, taken out of service, not put back into service until they're safe to operate again. Our last witness is going to be Sheila Davis. She is the environmental safety and health compliance officer. And she's going to talk about how important it is to the WIP and the employees at the WIP and management at the WIP to maintain compliance with their permits. And why this ACO has struck such a nerve. How it is so important to maintain a compliance history as good as you can. Nobody's perfect, but they're certainly doing their part to make it as safe as they can and assure compliance with this permit. She's got 25 years of environmental safety and health experience at DOE nuclear and major industrial sites. As the director of this organization at the WIP, she's going to talk about this being one of the top environmental safety and health compliance programs in the nation for the department. ACO rests on hearsay. They've readily admitted, there's no other evidence. There's no other proof that there were any violations of the permit. The GAO report and DNFSB are not evidence of violation. Therefore, there is no evidence of violations. This ACO must be dismissed or denied. Thank you.
Thank you. Mr. Jones is already sworn in.
I think
I just wanted to say really quickly that the Department of Energy completely agrees with everything that Mr. Woodward just said. And I wanted to underscore the importance to the department and to its contractor, Simcoe, of safe facility and safe operations with respect not just to WIP, but throughout what we call the complex. Because WIP is part of a much larger network of facilities throughout the country. And WIP is a nationally critical infrastructure asset because it is the only repository in the world for the types of waste that we take, the mixed transuranic hazardous waste. And so it's absolutely vital to continue the operations of this facility. And because of the importance of the facility to the nation and of safety to the continued operations of the facility, that is the focus. Safety ends up being the focus. And you'll hear from these witnesses about the robust training, inspection, verification, corrective action programs, quality assurance, maintenance, all the various aspects of the sort of the day-to-day processes and procedures that are followed to ensure safety. But to me, I come at this from a little bit different perspective. And to me, the most important thing is the safety culture, which completely underpins all of the efforts done at the operational level to ensure safety. And under that safety culture, safety is of paramount importance. It is much more important than how many containers of waste we're able to dispose of in any particular period of time. And it's important to know that all employees at the WIP have the ability to stop the work of the facility if they're concerned about a safety issue. And that does happen. and we wouldn't have it any other way. And so I just wanted to underscore, like I said, the emphasis on safety that not just at the WIP but throughout DOE. DOE has historically been an important safety leader, and the portion of the department that my facility, the WIP facility and the Carlsbad Field Office fall under is environmental management. So our focus is ensuring the protection of the environment, public health, and safety. And the way that we do that is that we safely characterize, package, transport, and dispose of waste from sites throughout the country that have generated waste from as far back as 80 years ago, starting with the Manhattan Project. Some of the waste, the first waste that we took from Rocky Flats, Colorado, was generated during the Manhattan Project. So this is an absolutely vital facility. We take this very seriously. Our compliance history and our relationship with the regulatory agencies, both in New Mexico and nationally, is extremely critical to us. So with that, I'll stop talking and let Michael proceed.
Thank you, Mr. Hall. Mr. Woodward.
Mr. Jones, where are you employed and in what capacity?
I'm employed at the Waste Isolation Pilot Plant with Simcoe within the Simcoe Environmental Program.
And how long have you worked at the WIP facility?
Just over 10 years. It's been about 10 years and 7 months.
Would you please briefly describe your educational background?
I have a Bachelor of Science degree in nuclear engineering and a Master of Science in environmental engineering.
Please summarize your prior professional experience before joining WIP.
Before joining WIP, I spent over 19 years in the environmental field. I've worked in both the federal and state government arena. I've also worked in the private arena, such as with Simcoe now. And in those capacities, I managed hazardous waste programs, hazardous waste management programs, air quality programs, surface water quality programs, petroleum storage tank programs, and environmental remediation programs, as well as emergency response programs.
Have you authored or co-authored professional publications in your field?
Yes, I have.
What is your current position at WIP?
I'm an advisory environmental compliance specialist.
And please describe the scope of your responsibility as an advisory environmental compliance specialist.
I'm responsible for environmental compliance with the WIP hazardous waste facility permit and with other regulatory programs. I manage a team, a permit inspection team, where we review the completed inspections by the responsible organizations that you saw in Table E-1. And we make recommendations on compensatory measures when those are necessary. I also teach two environmental classes at the site. The two that I developed that are currently in the permit.
Do your responsibilities also include monitoring and confirming that personnel receive appropriate training?
Yes.
Do you also monitor the permit for non-compliance?
Yes, we document other non-compliances with the permit when when they're identified, and we report that to the State of New Mexico Environment Department in an October report every year.
Have you held a role in any of major permit modifications at the WIP?
Yes, I led a successful effort in revising Permit Attachment F, which is the permit training program. We were able to streamline it with the RCRA regulations and streamline it by 90%. And NMED approved that it was a Class 2 permit modification. And more recently, during our permit renewal application, I was the leader of the revision of several permit attachments.
Do you consider yourself qualified to testify about the RCRA Hazardous Waste Facility Permit Compliance Program?
Based on my background, education, and experience, I do.
And do you have personal knowledge of actions taken to ensure compliance with the permit?
Yes, I do.
Mr. Jones, what is RCRA?
RCRA stands for Resource Conservation and Recovery Act. It's the U.S. federal law that governs the management of both the management of solid waste and hazardous waste.
And what is the primary goal of RCRA?
To ensure the waste are managed properly and for the protection of human health and the environment.
Does the WIP operate under a RCRA permit?
Yes.
And who implements RCRA in New Mexico?
The state of New Mexico, NMED, New Mexico Environment Department Hazardous Waste Bureau.
And the NMED has issued a hazardous waste permit to WIP?
Yes.
Does RCRA or the implementing regulations mention any mining safety standards?
No, they do not.
Does RCRA or any of the implementing regulations contain any prescriptive requirements for the operation, inspection, or maintenance of mining hoists?
No, they do not.
Are you familiar with 40 CFR Part 264?
Yes, I am.
How is Part 264 organized?
It has numerous subparts that would like subpart A, subpart B, numerous subparts.
And what do each subpart represent?
They represent topic areas for the management of hazardous waste.
And are specific facilities identified in the various subparts?
Yes, for tank management units, containers, container buildings, waste piles, staging areas, incinerators, landfills.
And do the Part 264 regulations contain specific types of requirements for the different types of waste management units?
Yes.
Those would be called prescriptive requirements.
Yes, sir.
What subchapter or subpart of Part 264 is the WIP facility covered?
Subpart X.
And what is subpart X?
It's titled Miscellaneous Units.
And why is it called that?
They're for units where hazardous waste is managed that don't fit any of the previous units, such as tanks, containers, container buildings.
Does subpart X contain any prescriptive requirements for mining operations or mine hoist?
No, it does not.
Are there any federal regulatory programs with oversight over mining?
Yes, Mine Safety and Health Administration.
Does MSHA have regulations specific to the operation of mines?
Yes, it does.
Does MSHA conduct regular inspections of the WIP?
Yes, sir.
Does WIP have a program to ensure compliance with the WIP RCRA hazardous waste permit?
Yes, we do.
And how is that compliance program organized?
Well, as I mentioned, I'm a member of the Simcoe Environmental Program, and within that program, we have Simcoe Permitting and RCRA Compliance Group. We have a Simcoe Environmental Site Environmental Group, and we have a Simcoe Environmental Sampling Group.
And do these groups all work together?
Yes, they're all under the Environmental Program Manager, which is Richard R. Chavez.
Does the Simcoe Permitting and RECRA Compliance Program look at all aspects of the mine to ensure compliance?
Yes, we do. As you noted in Table E-1, some of the permit inspections that are required do incorporate MSHA requirements.
Please describe the processes implemented at WIP to ensure compliance with.
Well, you know, we have a lot of deliverables required by the permit that we provide to the agency. So we have a large scheduling and tracking program to make sure we meet the times required by the permit. We have a inspection program at the site to make sure that we conduct and perform all the inspections required by Table E-1. The inspectors perform the inspections. Someone from their organization also reviews those, and then we do also the permit inspection team that we have to make sure that those inspections are completed accurately and thoroughly and have met the inspection frequency. We also have a training program, a RCRA training program that we track to make sure that people maintain their training up to date. And also we perform monitoring to make sure that when permit designated equipment has been taken out of service, that it has been returned to service.
So each of the people that are responsible for inspections or corrective actions or monitoring are all receiving training.
Yes, sir.
And that is ongoing training.
Ongoing, both continually initial training when they first start, if it's a new position for them, and continuing training such as annual refresher.
Are there follow-up inspections of facilities if there has been a corrective action conducted?
Yes, say as the pre-operational inspections you were mentioning, even though the corrective actions may have been completed, that hoist is not returned to service until another a successful pre-operational inspection has been completed.
How many hazardous waste facility permit required training classes are there? What is your involvement?
There are 7 permit required training classes. I developed 2 of them and I teach those 2.
Why is the RCRA training program important to hoist compliance?
It's important for hoist compliance because the hoistmen do their own inspections, and so they need to be trained to what are the inspection criteria, what is the inspection frequency, how to properly document their findings, and on the inspection sheet, the hoist operator log, and to provide comments of what they have noted during their inspection.
Is there any follow-up monitoring by your program in terms of making sure these inspections are conducted properly?
Yes, we, as I mentioned, the inspectors conduct the inspection. Someone from their organization reviews those for accuracy and thoroughness, and then they forward them to our group, and we also review them to make sure they've met the permit requirements, not only for accuracy and thoroughness, but for inspection frequency and to identify if there were any deficiencies that were noted.
What is the permitting inspection?
That's that team I was talking about. We not only perform inspection, we not only review completed inspections, but we also advise on compensatory measures for equipment permit designated equipment that's been taken out of service. We also perform key performance metrics that we report to senior management for the number of inspections performed each month and the number of deficiencies that were identified during that time frame.
Does the permitting inspection team conduct periodic meetings?
Yes, we do. In fact, some members of the team attend the plan of the day meetings every day.
What are the plan of the day meetings?
That's where the the groups within the site, at the site, such as facility operations, startup operations, hoisting, waste handling, identify what they're going to work on that day and identify the availability of critical equipment.
So it's to ensure the availability of critical operational equipment.
Yes.
Does WIP have a program to ensure emergency response capability described in the permit is maintained?
Yes, we do. There are a couple of procedures that deal with equipment out of service. When equipment is out of service, those procedures require compensatory actions to be developed and be identified and developed. And so for, say, if it's a emergency response equipment, WIP does maintain in some instances redundant backups. For example, we have an underground medical cart. The permit only requires one, but we have two in the underground. So if the first one needs maintenance, the secondary one will become the primary piece of equipment to demonstrate compliance with the permit. That is true for the underground fire suppression cart. We have two of those where the permit only requires one. And again, on the surface, we have surface ambulance. Permit only requires one, but we maintain two, so that if the primary piece of equipment needs repair or routine maintenance, the backup will become the primary piece of equipment to demonstrate compliance with the permit. Make sure we maintain that emergency response capability.
What is the WIP Emergency Operations Center? What is your role?
The Emergency Operations Center, when activated, provides emergency management decision-making support to the RCRA Emergency Coordinator and the Incident Commander. As a member of that, I'm a member of that team as the Safety, Health, Physics EOC team.
How does the compliance program handle permit specified emergency equipment that is out of service?
Well, as I mentioned, when it's taken out of service, we are notified, so is the facility shift manager. We make sure that there is some type of compensatory measure if it's not one of those pieces of equipment that has backup. For systems such as fire detection and alarm systems or fire suppression systems, the compensatory measure is a fire watch, and conducted by the WIP firefighters. And depending on the system, that can be as often as every 2 hours, every day, 7 days a week.
What is the WIP RCRA contingency plan?
That's a written emergency response plan that is permit attachment D, the WIP RCRA contingency plan. And it identifies responsibilities and discusses emergency response actions for various types of events at WIP, such as fires, explosions, or planned or unplanned, sudden or non-sudden releases, all with the goal of minimizing hazards to human health and the environment.
Is the contingency plan periodically reviewed?
Yes.
Are you familiar with permit section 1.7.7?
Yes, sir.
And what is this permit section require?
Well, it's titled proper operation and maintenance, and it requires the permittees to operate and maintain the facilities and systems necessary to comply with the permit conditions.
Are you familiar with permit part 2, section 2.10.1?
Yes,
What is this permit section?
it requires the permittees to maintain the equipment listed in permit part, permit attachment D, the RCRA contingency plan.
Are the hoist part of the required equipment?
No, the equipment listed in part 2.10.1 is internal communications, external communications, emergency equipment, water for fire control, and electrical backup.
What is permit attachment E?
That's the permit attachment titled inspection schedule, process and forms. It is the permit attachment that contains table E-1.
And what are the purpose of the inspection?
To make sure that our emergency equipment is operable in times of need, and it specifies the responsible organization, the inspection frequency, the inspection procedure, and the inspection criteria, all geared to making sure this equipment is operable when needed for the protection of human health and the environment.
But the inspection schedule is not just emergency equipment.
No, it's not.
It's a pretty extensive list.
Yes, it is. It also includes waste handling equipment. It includes basically like our waste hoist or equipment that we use to move transuranic mixed waste.
Referring to Respondents Exhibit 2, can you identify this document represents?
Yes, this is table E1 of the WIP hazardous waste facility permit.
Is the air intake shaft hoist a part of this
Yes,
table? How about the salt hoist?
yes,
And the waste hoist is also part of this table?
yes, it is.
And an extensive list of other facilities or items within the WIP facility. Correct?
Yes.
Are there inspection criteria listed for the air intake shaft, the salt shaft, and the waste hoist?
Yes, sir.
And what are those inspection criteria?
Deterioration, safety equipment, communication systems, and mechanical operability in accordance with mine safety and health administration requirements.
And are the results of these inspections recorded?
Yes,
How are the results of the inspections recorded?
they're recorded on a waste operator's log. There's one for each of the hoist that you mentioned.
What does the term pre-operational mean under the row label inspection or column label inspection frequency?
It means we conduct an inspection for that piece of equipment prior to its first use of that day that the equipment is going to be used.
And does the WIP conduct inspections in accordance with this requirement?
Yes, in fact, the hoisting organization goes beyond these requirements. They inspect, they do a pre-operational inspection every shift that the piece of equipment is in use.
So if a shift changes, within an operational day, another pre-operational inspection is conducted
Yes.
and they utilize the same criteria every time.
And they document it on the waste hoist operator's log also.
So the waste operator's log may have more than one inspection per day.
Yes.
Is deterioration defined in table E-1?
It is. It's in one of the footnotes at the back of the table.
And where would you find that?
At the back of the table on page 16, footnote B.
And what are you looking for according to this when you're looking for deterioration?
It includes obvious visible cracks, erosion, salt buildup, damage, corrosion, loose or missing parts, malfunctions, and structural deterioration.
If a hoist is taken out of service because it fails any of these criteria, when can it be put back into service?
But when it's taken out of service, an action request is submitted to for repairs, and it's not, even after the repairs are completed, it's not returned to service until another pre-operational inspection is successfully completed.
I'm going to direct your attention to Respondents Exhibits 5 and 6. Do you recognize these documents?
Yes, I do.
And what are these documents?
These are the waste hoist operator's logs for the waste hoist and the other one for the AIS hoist, the air intake shaft hoist.
Do the documents represent any time period?
For the waste hoist, it's for the time period from March 2nd to March 30th, so a month there. And for the AIS hoist, it's from March 1st of 2024 to March 30th of 2024.
Are these hoist logs representative of hoist logs from the rest of the year?
Yes, sir.
These are examples from March 2025.
Yes.
Do these hoist logs indicate the criteria that have been inspected
Yes,
for on the hoist?
they do.
Have these hoist logs been provided to the NMED?
NMED performs an environmental compliance inspection at the WIP every year. And it's usually in two phases. The first phase is the physical inspection of the facility, where they come and inspect the surface facilities and the underground facilities. And then before they leave us a requested documents list. Sometimes that list is 2.5 pages long of records and training records they want to have provided to them so they can review those. And the actual inspection is not completed until they've received those and had a chance to review them. And so, yes, every year they ask for hoist inspection records.
What is your role during the inspections from the NMED?
My role mainly is during phase 2, where I take the requested records list and start gathering those and getting those assembled, such as you see here in grouped by month, and provide those to the NMED, not only for the inspection records of the hoist, but all the other equipment listed in Table E1, as well as the training records for the people that are using that equipment.
It's referred to Respondents Exhibit 7. Can you identify this document?
Yes, this is the requested documents list that NMED provided to us during their May 12th, 2025 inspection at the WIP facility.
And did the document, in this document, did they request the waste or the hoist operator's logs?
Yes, in line item 10, permit required inspection records, they requested the air intake shaft hoist pre-operational inspections from April 2024 to May 12th, 2025, so just over a year's worth of records. And they also requested the waste hoist records for the same time period.
And did you provide the inspection logs in accordance with this request?
Yes, I did.
And Exhibit 5 and 6 are examples of the type of information provided?
Yes, sir.
Did you participate in the exit inspection after the 2025 record inspection?
Can you repeat that, please?
Did you participate in the exit interview after the 2025 record inspection?
Yes, there was an exit briefing in November of that year.
Did NMED express any concerns about the condition of the hoist?
No, they did not.
Have you reviewed the administrative compliance order that was issued to NMED in this matter? Issued by NMED in this matter?
Yes.
Have you also reviewed respondent's original answer and request for hearing?
Yes.
In your words, what does the ACO allege?
It alleges that DOE and Simcoe failed to maintain critical infrastructure in accordance with the permit.
Do you agree that Simcoe has failed to maintain WIP infrastructure in good repair in violation of section 1.7.7?
No, I do not agree.
And why is that?
We followed the permit process, the process identified in the permit for rigorous permit inspections. We review those permit inspections not only from their own organization, but by another organization such as ourselves. When corrective action is needed, it is identified on the inspection sheet, and the action request number is noted on that inspection sheet accordance with the permit. So there's that transparency of an issue was found. Here's how it was addressed, and you can track it to completion through our action request system. And even in our action request system, there's a checkbox there that if this is permit designated equipment, the people completing the action request, when they submit it, they can check that box, and it warrants higher priority for that system or equipment.
Do you agree that Simcoe or DOE have failed to maintain the escapeway hoist?
No, I do not agree.
They claim that's in violation of 2.10.1. Why do you not agree?
Um, when when deficiencies are found during the pre-operational inspections, the hoist is taken out of service and it's not returned to service until that deficiency has been corrected. And even after it's corrected, uh, it's not returned to service until another successful pre-operational inspection is conducted.
In your opinion, is it a violation to take a hoist out of service?
No, in fact, that is the goal of the inspection, is to make sure that that piece of equipment or that hoist is safe to perform its intended function. Such as with our firewater pumps, we do firewater pumps inspections weekly. Sometimes we see that permit inspections identify deficiencies. And so that permit inspection has done its job. It identified uh, a piece of equipment we need to focus on before there is an actionable emergency.
Is it your opinion that such an action is an effort to maintain equipment in good repair to maintain compliance with permit conditions?
Yes.
Do you agree that there's a disconnect between inspection findings and maintenance response at the WIP?
No, I do not agree.
The allegation in violation 3 is that WIP has identified concerns or identified problems with equipment and has failed to timely fix it.
No, I do not agree.
Why is that?
We do have aged equipment, but sometimes when it is taken out of service, it may take some time to procure spare parts or to have spare parts manufactured, or sometimes we need to bring in a vendor to identify what is the root cause of that problem. So sometimes that can take time. But that hoist is never placed back into service until it's safe to operate, and it has demonstrated successful pre-operational inspection to meet all the inspection criteria in Table E1.
Is there any requirement in the record permit specifying a time upon which a piece of equipment has to be repaired?
No.
In fact, it'd be a violation to put a piece of equipment back into service before it being repaired.
Yes.
That's not happening.
No.
Do you agree that permittees have failed to maintain hoist integrity for design basis events?
No, I do not.
And why is that?
As I mentioned, we go above and beyond the inspection requirements of the permit. We perform for the hoist, we perform that each shift that it is in use. And again, repairs and upgrades have been made to the hoist, such as the waste hoist replacement motor that was recently accomplished. So I do not agree with that.
Is there any requirement in RECRA or RECRA regulations or the permit that equipment be requalified to design basis?
Not that I'm aware.
Has WIP received any request from the NMED other than the ACO to requalify the design basis?
No, sir.
Do you agree that the alleged inaccuracies in the FEMS condition data constitute a permit violation?
No, I do not agree with that.
And what's the basis for your opinion?
Numerous searches through the permit. I work with the permit every day. There is no FEMS requirement to create or maintain a FEMS information system.
Is monitoring of the FEMS program even within the record compliance program?
No, sir.
In your opinion, as a record expert, do you have an opinion whether the GAO report or DNFSB letter findings of noncompliance indicate noncompliance with the permit?
No, they do not. They are not regulatory authorities.
Based on your experience and your review of the records, what is your opinion regarding the safety of the continued operations of the hoist?
Based on the training we provide for the individuals operating the hoist and the exceedance of the permit requirements for inspection, and based upon what we do see when the inspections are completed, it's my opinion that the hoists are operated and maintained in a manner that will afford continued safe operation of the hoist or underground activities.
What is your opinion regarding whether the WIB compliance program meets the requirements of the permit and protects human health and the environment?
I believe we do meet the requirements of the permit. We have a very comprehensive program to make sure that we meet the deliverable schedules in the permit. We have a very good training program for the individuals that are performing these inspections and using this equipment, not only for classroom-based training, but also for on-the-job training and job performance measures. We have a good monitoring and tracking system for making sure equipment is returned to service, such as for fire detection, alarm, and fire suppression systems. We have a good system for emergency response capability. We have redundant backup equipment. We have a very robust environmental compliance program, the website.
That's all the questions I have.
Thank you, Mr. Woodward. Mr. Knight, will there be cross-examination?
Yes.
Would you like to do that in the morning, or you would? Okay. Yeah. It's close to 5, and if we aren't packing up and leaving time, they make us exit through the garage, which you do not want to do.
Okay,
So we'll see you tomorrow morning at 9 o'clock here.
very good. Thank you.
Thank you.